May I mention, Lords? Lords, one matter, fresh matter for preliminary hearing, may request, Lords, for posting sometime next week. Lords, land revenue matter, Lords, the order has been passed. I was not made as a party. My vendor was a party. And my vendor has remained ex parte before the proceedings in the writ court. And by pursuance of, in pursuance of this order, Lords, the revenue entries which are standing in my name have been changed now. Only thereafter I come to know about the order.
Leave to appeal.
Yes, Lords. Leave to appeal.
After 10 days.
Any date after 10. Oblige,
With my Lord's kind permission, my Lord, this is a matter pertaining to medical college, wherein the students came before this honorable court after completing their fifth semester, my Lord.
It is writ petition or writ appeal?
It's a writ appeal, my Lord. I am submitting, my Lord. Insofar as in the writ appeal, they in the writ petition, they came before this honorable court and sought that because there is a deficiency in infrastructure, they would like to deposit the fees before this honorable court. This honorable court directed them to deposit the fees, my Lord. Thereafter, at the time of final hearing, my Lord, this honorable court passed an order directing MCI to inspect, and after the inspection, the fees to be granted either to the students or to the medical college, my Lord. But then MCI did not come and inspect, but the students were transferred. The state government transferred them. And by virtue of that, my Lord, for the 5th and 6th semester for which the education was imparted to the students, my Lord, they deposited the fees here. And we also made an application for releasing of the fees. They also made an application for release of the fees, my Lord. This honorable court, after the decision was rendered on 7th of February, directed the student to collect the fees, my Lord.
What do you circulation?
But
what do you want?
My Lord, kindly take it over on Monday, my Lord, because if the students withdraw the fees, my Lord, the college will be, because we have our commitments which we could not do it since 2019.
Not Monday, but
any day of my Lordship. Second, my Lord.
You can go to 15th of April.
No, my Lord. By that time, the students will withdraw the money, my Lord. Nothing will be left, my Lord.
4th April.
We want very well. I am grateful.
Explosive matter. When I am running a cracker shop, please, my Lord. The premises was I was issued a notice to seal the premises because the fire engine cannot come to the premises in case of mishap, please, my Lord. I filed a writ petition. The writ court directed the BBMP to verify what is the status of the road. The report says that fire engine can come. In spite of that, my petition was I was permitted to withdraw and file a fresh petition. I have challenged that order, please, my Lord. If they take precipitative action, then my premises will be sealed, please, my Lord. Monday, please, my Lord.
16th February.
Lordship, kindly, one contempt matter for admission, Milord. This is alternative site. There is a direction for allotment of alternative site within 3 months, Milord. So far,
it will be listed once you remove the office.
My Lord, it's a
after lapse of 1 year when the matter has not been listed before the court.
No, it will be listed. Why you are apprehensive? It will be listed.
Please.
Yes. No memo. Not to be accepted. It will be listed. Give the number only. Don't give me. Yes.
Education, medical education matter. Despite the Honorable Supreme Court directing that inter se merit has to be maintained in these matters, and the Principal Secretary Medical Education directing the Director of Karnataka Examination Authority that this student is deprived of her seat in 2022, you have to consider our case in October 2023 as directed. That direction is not followed. Total fraud on the case. It's 2022 matter. Supreme Court has said inter se merit. In the very same matter, Supreme Court has observed that inter se merit has to be maintained in sports quota. Some urgency because reservation of seat has to be there. Grateful.
One matter. Any irrigation facility which has to be irrigation facility or provided in the provisions of the Irrigation Act. But first of all, the lands have to be identified. First of all, lands have to be identified. But wherein without identification of the lands, Lord, the officers have given facility, irrigation facility, wherein the beneficiaries, officers themselves are the beneficiaries. Actual small holders of the land have been deprived with the irrigation facility. But there is a urgency, my lord. Matter was already heard for some time, and some directions were issued to the respondent officers.
It is pending.
Yes, my lord.
File IA.
The IA was already filed, my lord. Matter was posted for hearing.
We will not prepone in that way, oral mention. Yes.
My lord, the petitioner's license has been pending since 2011, my lord, the application. And in spite of a direction of this honorable court in 2019 to consider the application, my lord. And we have issued a number of representation and it's still been kept pending, my lord. Hence, there's urgency, my lord. May the matter be listed in the coming week.
Some date must have been given in that matter.
My lord, they haven't given any dates to appear as such, my lord. The latest
Verify whether it
representation.
is, any date is given, not given. Get it listed on 16th of April.
Yes.
My lord, both the parties have been granted divorce, my lord. And according to the order and judgment of the Honorable Family Court, there's a joint custody of the minor daughter who's a special child, my lord. Now the mother has cut off all the communication with the father, my lord. And since March 8th, we have not had any communication with the minor daughter, my lord, who is a special child. It is against the orders that is passed by the Honorable Family Court, my lord. Hence this urgency, this is a contempt petition, my lord. On Monday, my lord.
Wednesday.
Much obliged.
My lords, this is a PIL. So this was a case against a temple where they were harassing an elephant. Now the honorable bench had directed the forest department to do an inspection and give the report. The last date during 2022, the department was not able to give the report and they had asked for extension of time. Now the report is ready and it's found that the elephant is missing from the temple premises. And since 2022, this case hasn't been listed.
Pending matter. Pending matter.
Yes, pending matter.
Date is given.
Date is not given. It's
Case for IA, you file IA, it appears. You want some order?
we want to proceed with the inspection report.
You want the production?
The report that the forest department has, we want to produce it and go forward with the case.
Who are you?
We are for the petitioner, for People
PIL.
for Animals, PIL.
Petitioner.
Yes.
What's the urgency?
Urgency is that the elephant is not there in the premise of the temple and the inspection was done. And it
17th.
is-
17th April.
Thank you.
May I seek leave to mention, Manoj? No, I'm mentioning seal number 38 before. I'm appearing for the third respondent in that case.
38.
38 minutes. There's some difficulty, Manoj. Matter was, the date was earlier not given for today. Learned senior counsel is appearing for the third respondent, Manoj, is traveling. And Manoj, we're not able to log into the VC, Manoj. I believe there is some sort of a firewall. Therefore, he's not able to log in also, Manoj. Therefore, I'm seeking leave, Manoj. It'll be taken up any day next week, Manoj. We'll make arrangements, we'll go on with the matter.
Force, my lord, because in this matter also, my lord, there is a senior counsel. There was a proposal direction by this court to, my lords, submit a report.
One thing we request you,
Yes, my lord.
not on the ground that some senior counsel is appearing. That is not the criteria for us.
Sorry.
Urgency of the matter is nothing else. All counsel are equal.
Yes, my lord.
With their lordship's with their lordship's most gracious permission, my lord. With their lordship's most gracious permission. With your lordship's most gracious permission, am I audible, my lord? I tried
Yes.
yesterday and another day, previous day also. My lord, the Justice Barale, the Honorable Chief Justice, was pleased to specifically pause this matter on the month of November, and it was never been listed. And my lord, this is an appeal against an order vacating and direction to restore possession. And for my non-appearance, my lord. So the respondent was directed to show cause to restore possession or to show cause why possession shall not be restored. See, my lord, therefore it was a nature of a writ of prohibition. Sorry, mandamus. Sorry, mandamus. Sorry, a mandamus was issued. An interim mandamus was issued, and then my lord, they filed a counter affidavit, and I couldn't appear. The primary reason was that I was not well, and on other occasions I had to face some difficulty to enter online. And this matter had come not less than 6 times to Bangalore, and the matter somewhere may not been pending for pretty long time.
It appears it's a surfacey proceeding.
Yes, my lord, the whole issue is, one is I'm an MSME, I'm entitled to the protection of the MSME Act, no recovery proceedings, either under surface or any other law is permissible without the committee being constituted and the benefit of the notification be extended, number one.
Want to get it listed?
And the second aspect, my lord, even if recovery is permissible, then the present yes.
Mr. Nedumpara, are you arguing on merits or you want the matter to be posted?
No, my lord, I am only any day near to your lordship's most gracious convenience, my lord. That's all, my lord. That's all. And I would prefer to appear online, my lord, any day, my lord, of your lordship's convenience.
20 on 18th of April.
18th of April. Greatly obliged, my lord.
Please mention the case number, sir.
1045. Writ appeal number 1045 of 2023. Writ appeal number 1045 of 2023. Greatly obliged, my lord. Greatly obliged.
Please.
Could be taken up on 4th, my lord.
Please.
I'm grateful. 41.
41.
41.
It will 27 by 2024.
So what do you want? Time? Beyond vacation.
My lord, this matter was heard by lordship and there is an order of status quo and formation of the road is stopped. That's the reason, my lord, lordship has given today date. Today's date, my lord, because the matter was heard for some time.
You want time? It was heard.
4th, it may taken on 4th, my lord.
It was heard.
Yes, my lord, for some time, lord.
Not 4th now. 15th of April.
Yes, short.
Not 4th.
My lord, serial number 19, my lord. My colleague who is arguing the matter has suffered a loss, my lord. Any date next week?
19.
19, my lord. Appear for the appellants.
Let it go. Refund of some amount.
Yes, my lord.
Tuition.
Any date, my lord, after 1 week?
After on the reopening.
And permission.
Let it go to June.
My lord, sir. Serial number 18.
5th of June.
Seeking for short accommodation.
18.
Serial number 18. Due to some inconvenience, my senior couldn't appear.
Go next after 7th of June.
Serial number 1.
The order other print again.
Here there is no office of office. First is not 4.
I'm sorry, my lord, if there is any.
No, not your mistake. Not your mistake. Yes.
Contempt matters, cell number 3. The Karumbaya TA.
Appear for the complainant. Final order is on the page 40, annexure C. Direction is at page 44, my lord. The permit is pleaded, my lord.
This notice.
The above
I accept for R3.
R3.
The above having been said,
Or learned education, miss, what's your good name?
Chitara.
For the complainant, notice returnable on 4th June, 4th June,
Early date, my lord.
early 22nd April. Learned government employed, okay, Mr. We have R3. R3.
Second April. Cell number 4, Mr. Subramania Bhattacharya.
For the complainant, my lord. My lord, order of the learned single judge is at annexure A, my lord, wherein the order of suspension was set aside and held that all petitioner is entitled for all the consequential benefits. Challenging this order was not complied, hence I have
Notices.
initiated contempt proceedings, my lord.
Order notice, same 5th of June.
Great.
Cell number 5, Shrimati Rakshita DJ.
There is an order directing the respondent to execute the sale deed to allot the site. That is page at 17, my lord. Date of the order is, my lord, 20.
Notice 6th of June.
I accept for R1.
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 PGA.
Learned government.
Cell number 6, Mr. Hirematar.
6 also, decide by the time. 6th of June. You are appearing for whom?
Order number 2.
Second respondent.
Second.
Second.
Cell number 7, Mr. Mohan S.
For complaint. Direction from this honorable court to the accused to allot a site is already not
Some
allotted.
site to be allotted. Interim orders.
Interim order.
This is interim order.
Contempt is against interim order.
Interim order.
You have to work out there only. We have taken that view.
Page number 50, my lord. Clear direction has been issued. They have violated
For
the-
learned advocate, Mr. Mohan S. Complainant. Full stop. This contempt application is filed against order dated 14/9 in respect of order dated 14/9/23, which is an interim order passed by learned single judge. The proceedings of regular first appeal number 775 of 15. Since it is interim order, the court is not inclined to invoke the contempt jurisdiction, leaving it open for the parties to approach the learned single judge, and work out rights and remedies in the proceedings pending before the court concerned. Present proceedings are accordingly disposed.
Number 8,
For the complaint, my lord, direction will to consider the case of the complaint for the appointment on compulsory down, my lord. Since is litigating in the 2019, my lord, and the accused is directed.
Notice 5th of June.
Since
Or to
4
the
years, my lord, she
AGA.
is agitating, my lord, for getting the compulsory appointment. Earlier occasion, my lord, is the direction. Direction is overlooked, my lord. Having that, he is a Gram Panchayati employee, his father. Now, my lord, the court has directed to treat him like the municipality employee.
We are issuing notice.
Notice has to go. R2 for AG.
That date, my
GA
lord,
for
since
R2.
5 years, he is litigating, my lord.
already issued.
Issued.
No, no,
First time it has come.
First time.
first time.
Nine, do appear for second respondent. Eight.
I'm sorry.
See that it is complied with. If it's no appeal is.
Urgency, my lord.
Process. It has to.
5th of June. Seal number 9. Suresh Babu.
There's an order passed by my lords, the last date of hearing. Order sheets may kindly be produced, my lords.
Yes.
Lords, now, Lord, with your lordship's kind permission, Lord, now I have been served with the affidavit saying that the BDA has complied the request that is been made by the complainant before your lordships. Lords may kindly appreciate. It was the request which was made to the BDA was that, my lords may kindly take page 14. I had made a request that the society has executed a relinquishment deed. As per the relinquishment deed, what are the CV community sites parks that were relinquished? The BDA will become the absolute owner of the said property. The BDA has to take possession of the same and hand it over to the BBMP.
Direction is to consider representation.
Now, Lords, kindly, one short submission, Lord.
Complied.
It'll open up another public litigation,
That
Lord,
always happens.
because they have not taken the possession, Lord. What they're saying is they have corresponded with the society. Lord, I may kindly be permitted to file objections, Lord, at least 1 week, Lord.
So contempt is a matter between court and the alleged contemptor. They have said the direction is consider your grievance in terms of the representation.
I'm sorry,
Complaint.
my lords, I have
My
not filed the
request was to
translations.
take possession of the property, Lord. That is not been complied.
That is not the
That is
order.
only my request, Lord.
Request is
Lord,
not
in
an
the
order.
request, Lord, in the request, in the representation, I had specifically requested the BDA to take possession of the properties which were relinquished as per the registered relinquishment deed and hand over to the BBMP for further development. Lords may kindly take page 14, Lord. That was my request, Lord. They now say that they have corresponded with the society and still they are not in a position to take possession, Lord.
Both me and you have to read standard books on law of contempt.
It is done.
My lords, we have issued a notice and we received a reply and we have intimated to the complainant
May-
also, my lords.
I may kindly be reserved liberty, my lord, to file a fresh petition, my lord, because it is once again open up of a fresh petition for public litigation. Because they have not taken possession, that is my respectful submission.
It was regarding what, some layout?
Please, my lord,
Lords, the
Taking possession of a particular.
civic communities that were relinquished. That were relinquished under a registered document, my lord. Now, despite there is a relinquishment deed, the society is not handed over the physical possession to the BDA.
Learned advocate, Mr. Francis,
B. Vachan,
appearing
Lords.
for the Bangalore Development Authority, produces affidavit of compliance. Post of the directions, correct, directions of learned single judge. Supposed to decide the representation of the petitioner. Which is done by the competent authority, the Bangalore Development Authority. Since the representation is decided, as per the compliance affidavit, nothing survives in the contempt proceedings.
I may kindly be reserved liberty, my lord, to file
If any grievance persists with the complainant, the only remedy is to institute independent proceedings. In respect of which this court does not express an opinion on matters.
oblige, my lords.
The PL matters, seal number 10. Mr. J.R.
Therefore, petitioners, my lord, in this writ petition, I have sought for a direction to the respondents to consider my representation.
Opening of, starting of hospital.
I have sought for a direction to the respondents to consider my representation for upgradation of the government hospitals to the taluka level hospitals, my lord.
What is the law relating to upgradation of the hospitals? Which law? Which is the normative process?
Yes, my lord.
Show the law.
Yes, I will show, right now I do not have, I will produce the document, my lord.
No,
My lord,
you
when-
time that way.
Yes, my lord.
You are not the respondent, you are the appellant, you know how you
Yes.
have drafted the petition.
Yes.
Appellant. Therefore, you should have shown the, show us what is the normative process and show the fault lying on the, those who are associated with the
My lord.
process.
My lord, at present, the hospitals which have right now,
At
they do
present,
not have
war is
even the
taking
basic
place elsewhere,
facilities,
that's
my
not the
lord.
argument. Show the law. We're asking simple things now. It has come to that level now.
Yes, yes.
We're sorry. Show the law.
Yes. My lord, I'll produce the relevant documents. A week's time may kindly be granted. I will produce all the documents, my lord. Because of the not providing of the hospitals, the facilities, my lord, the people have been facing much hardship and inconvenience, my lord.
Upgrade the arm factory. How, what is the basis for that?
Yes, my lord.
These matters take away
Yes.
the time of the court, which otherwise we could have diverted for worthy causes of
Yes, yes,
laborers,
my lord.
the depressed classes. This
Yes,
is how time
yes.
is wasted.
Yes, my lord. My lord, in the year 2018, 3 new talukas are formed in the Bidar district.
We do not know all that. Show the law. You are in the law court.
Yes, yes.
You are not before Queen's bench. You are before the court of law. Show.
Right now, I do not have. My lord.
Right now, we cannot have.
My lord, a 1 day may kindly be granted. I will produce all the documents required by this honorable court, my lord. Please, my lord.
This is the quality of at least a section of the bar.
I'm sorry, my lord.
Except law,
I'm extremely
everything will
sorry.
be argued.
Number 11, the Saurabh RK.
I appear for the appellant's counsel. By circular at annexure F, page 231. Volume 2, page 231. Apart from introducing a new software with regard to registration, a circular is issued that on presentation of the document before the sub-registrar, he is required to upload it. Rather, the person who presents it is required to upload it, which will be sent to what is called as a borderless, jurisdictionless, faceless scrutiny that is supposed to be done within 24 hours. If they don't do it within 24 hours, it will be sent to another office, etc. None of these things are authorized to be done under the provisions of Registration Act. Actually, something of this sort was earlier done. Supreme Court struck down that.
First, we should go with some.
Made Supreme Court struck down in that state of Rajasthan versus Basant Kumari case. It's again the same thing is being done.
Which is the
Please,
judgment?
ma'am.
Which is the judgment?
Citation. (2005) 12 SCC, page 77. It is at serial number 4, page 51 of the compilation.
Notice.
Following this, earlier notification was struck down by this court. Again, they have done the same thing.
Notice written. 5th June.
But I had sought for an interim order with regard to sending it to jurisdictional office, etc., not the entire thing.
That day we'll still consider. On that day.
Would your lordship,
5th of June.
please.
All respondents. One in.
Number 12, Vishwanath Sabrat.
My lords, I appear for respondent number 224, my lords. I undertake to file wakalat. A short accommodation may be.
It's a PIL matter, lordship. It's with regard to this manufacturing of faluda and badam milk and ice creams on the roads, your lordship. On annexure B, your lordship, page number 35.
Similar matter was before us.
Day before yesterday, your
Same-
lordship.
same
So,
matters.
yeah,
It is same matter.
your lordships asked me to serve the council of BBMP and then
Same
let.
notice.
My lords, a short accommodation, my lords. I wait to file wakalat.
Any urgency?
Notice may be issued.
Formal notice.
Notice has to be issued.
Will issue notice returnable on 18th of June, 18th of April.
Much.
Grateful, my lords.
Are you accepting the notice?
First respondent.
Please accept.
Accepting the notice?
224.
224.
Yes, my lords. BBMP.
Said Prashant.
One below per. What is your name?
1678.
224.
18th April. It's Green bench matter.
1 and 8 also you can take, no?
Yes.
168. 16, 7 and 8.
16.
Much okay.
December 13, Green bench matters. LM Siddhan.
Give the petitioner the notice.
Has been sent through mail.
So I've received a copy of the statement of objection now, and will be looked into and make submission. It may be called after vacation soon.
Sir,
Covered by judgment.
Overlapping area.
I'll look into
We
your-
ought for texture.
I'll look into and make submissions, your lordship.
Very
Copy is
beyond vacation.
beyond vacation, it will be granted.
It will
Both the
go to
matters.
10th June.
Not issued. Formal notice has to
You are accepting notice.
GA for respondents.
I have filed already.
But notice was not issued in order. Perhaps they have served a copy.
18 June. Huh?
Yes.
December 14, Suraj Nayak.
My lords, the counsel appearing for the petitioner is unwell, my lord. A short accommodation may be granted.
Not well.
Not well, my lord. Medical emergency.
After vacation.
After vacation.
Please.
June,
18 June.
12th June.
12/6. December 15.
For the petitioner, my lord, I've been instructed to withdraw this matter, my lord. This matter may be disposed as withdrawn.
Learned advocate, miss. What is your name?
What's your name?
Rashmi, my lord.
Rashmi.
I appear for Parshurama Jampur Lakshman.
For appearing for learned advocate Parshuram. The video conferencing was permission to withdraw the presented petition. Upon instruction of the petitioner, permission is granted. The petition is dismissed as withdrawn.
Grateful.
December 16, Aditya Narayan.
Appear for the but the pursuant to the Supreme Court judgment in Samaj Parivartana case. Some of the mining leases were cancelled and Supreme Court directed that it should be auctioned. I am the successful bidder in the auction. And the Supreme Court said that whatever clearances and consent which the earlier mining lessee had, that should be transferred to the successful bidder. But pursuant to that, we obtained all clearance. In respect of forest clearance, Lord, the state government refused to transfer the forest clearance in favor of this son. So I obtained for a fresh mining lease. Now, according to the terms and the conditions of this auction, I have to commence mining operation within a period of 18 months. Now, I could not commence because there was delay on the part of the state government in transferring the forest clearance. And ultimately, I obtained a fresh forest clearance. On the ground that you have not commenced operation within a period of 18 months, they are have imposed a minimum guaranteed dispatch of 72 crores on the petitioner. In similar matters, in respect to this matter, 72 crores, I have agreed without prejudice to my case in this writ petition. I will pay in 9 quarterly installments. I have paid 2 quarterly installments. But the validity of this levy needs to be examined because in a similar case, I have produced the judgment of the division bench that when I become the successful auction bidder, whatever consent which the earlier lessee had needs to be transferred to the auction bidder. This is the judgment of the Supreme Court. Kindly see, I have produced the Supreme Court at page 60.
But you have acquiesced in the impugned action.
Yes, Lord. It was one of the conditions in the auction that whatever consent it was there, it will be transferred to you. In fact, I have prepared a...
While paying two of the installments, you have already paid.
I have paid, my lord. I have made it clear without prejudice.
Where is that?
That, my lord, I am producing that letter. I'll put it. Because if that period expires, then I am left without any remedy. 5 years period will be over.
Notice was 17 August 2023.
Yes, my lord.
Yes, pursuant to this, you made the 2 installments.
2 installments.
Which date you made those?
At page, my lord, 3 of the memo. At page 6.
Why this is not made part of the petition book and why memo?
Some mistake, my lord. That's why I had kept it ready
Because of that doubt arises.
Not deliberate. That is why I am making this as the first statement. Page 6, my lord, para 15. Serial number 15. We are ready and willing without prejudice to remit the sum calculated arrears after giving us the relief of 6 months in 10 equal installments. First installment shall be paid. Page 7, we paid 9 crores. And another 9 crores. 2 installments have already been paid. Now, with regard to this plot, there's one of the condition in the sale auction notification itself at page 11 of the, which is part of this auction notification under which I became the successful bidder at page 11. This is general information about mineral block. This was part of the tender note at page 11. Particulars of statutory licenses, permits, permission, concession, approvals, and consents related to mining operation. At page 11, bottom part B of the memo. At page 11 of the memo. All the materials are not produced. Along with the petition, there are suppression and producing the letter.
Notice is not at order.
Accept notice and file.
By submitting memo dated 28/3/24, learned senior advocate for the petitioner places on record documents which include the representation, receipt of payment, and other relevant extracts, as well as the relevant extracts from the tender document.
The lordship permits, my lord, will deposit the money in court itself. Because once I pay the money.
No, you have made it two installments, you have already paid. Go on making payment and subject to.
Yes. Can I deposit in court,
Notice
my lord?
returnable on 6th of May, 6th of
Lord, your
June.
lordship may kindly observe that any payment made will be subject to the result.
That
Otherwise,
will, that itself will be arguable.
Yes. No,
Because
no.
that is the contention which you have taken.
Correct, but that
Let
is
us see that.
my submission.
Even
my
in the
lord.
sale deed, they have agreed. I mean,
No, no,
lease
that-
deed, I might.
That, my lord, it is a clear case where the government after
Page number
giving an
395.
assurance that forest clearance
Page
will be
number
transferred.
395 in the
Identical matter is
registered
already
lease deed.
decided. Now, in respect of the payment, my lord, your lordship may say that subject to the, I'm not saying.
It need not be said because it is always there. You have said in your para 16.
Sometimes, my lord,
which you have
arguments will
produced
be
this one.
advanced that they have accepted. What I am saying is, I have made it without prejudice. Your
Para
lordship may
13.
say that I'll go on making payment with
Para
subject to
13.
whatever orders. I am open to whatever your lordship decides ultimately.
Payment should be subject to outcome of the.
What payment you are making now further?
Now, 2 installments I have
Course, yes.
paid. Now, remaining, remaining 6 installment I have to pay. 6 installments I will pay subject to the result of the.
So far,
writ
about,
2 installments he has paid.
what amount is paid so far?
Now, my lord, about 18 crores have been paid. And another, they have permitted, this offer has been accepted without prejudice. Remaining 6 installment I will pay, my lord, subject to the result of the writ petition.
Learned senior advocate stated that rupees 18 crores, give the exact figure, has been paid to the authorities.
That is, my lord, exact figure.
The total dues which are which are calculated to be 72, 20, 74, 552. Full stop. He states that further amount of rupees 20 crores will be paid before.
No. All the remaining 8
All
installments.
amount will pay, whatever
All
All
demanded.
remaining 18.
But
64
64 crores he has to
installment.
pay.
Yes, yes.
What next he will pay?
Now, according to
As per
their
his
own
undertaking, he
condition,
has to pay.
pay the money.
Will pay.
As per
subject
the
to
schedule,
result.
subject to outcome.
That's all.
Learned senior advocate makes a statement that the petitioner will pay the amount as per the schedule.
Subject to outcome of the.
Full stop. The basis for interim relief. However, no interim relief can be granted except observing that the payments will remain subject to the outcome.
Doesn't matter. Then really love.
Number 17.
Do I give the exact figure, my lord?
No, they are not finished.
Lord, the Union of India is also a party. Notice I may have to.
Notice is ordered already, perhaps.
ಇಲ್ಲ, ಇಲ್ಲ, ಆಗಿಲ್ಲ. First time.
First time.
In 17,
Yes.
notice.
Notice has to go. First respondent is Union of India, ESG.
But I accept for R1, 2, 3. R4 and 5 notice has to.
ESG.
14th June. 14th June.
69.
16. I'm sorry. Serial number
I too.
16 I am making.
17. In 16 notice has to go. We have done. Shanti Bhushan irbe. Shanti
We are
Bhushan.
saying about 16.
16. 16 notice.
Obliged.
4 and 5. Number 17.
Please, my lords. Herein, the petitioner was granted a query lease, which came to be expired before 12/8/2016. Later on, for a deemed extension, he made an application, which also came to be rejected. But by virtue of 2023 amendment, and the other day, my lords were pleased to hear me, on the same day, it may be heard also.
We'll have this after judgment would come. We have already heard you in another.
Identity matter is posted on 30th May, my lords.
It's a different part. No, another matter we have already heard.
Yes.
Already.
Day before yesterday only, probably.
Please,
So we'll post this on 23rd April.
Second.
Notice returnable on 23rd April, learned the government advocate, Mr. Mahendra. Accept notice on behalf of
Lord, this is covered by the judgment of this honorable court. It is not in respect of deemed forest, Lord.
No, no.
No, deemed extension.
Deemed extension, that is what, Lord. They are seeking the extension under 2023 amendment.
That we have,
That your
day
lordship
before
has a-
yesterday, we have heard one matter that we have only reserved that matter. We did not. It's also covered. That's
Therein
also
only
covered.
the
Covered.
learned government advocate filed the statement of objections and it was posted yesterday, which came to be adjourned on 30th May, my lords.
The application never pending, same.
Yes, yes. It may, if need be same, on the same day, it may be heard also, my lord.
It will be listed on 22nd of April. At the time.
Yes. Please, my
Even otherwise, that justice.
The other judgment is covered, the
bench.
division bench covered that.
Your lordship.
Mukherjee's judgment. Even
Justice of.
Mukherjee's judgment.
22nd April.
Please, my lord.
18 and 19 are adjourned. Still number 20. Anjana CH.
Pertains to the withdrawal of appointment made to the technological university by the state government in perpetual exercise of doctrine of pleasure. I was appointed as a member of the executive council on 23rd March 2023.
What section 19 says?
19 says, Lord, that the state government would be open for the state government to appoint 3 persons to the executive council. 19 subsection 3 clause D. If lordship's permit, I'll just pass on the act. Nineteen subsection. 19 subsection 3.
There's one judgment by Honorable Justice Arvind Kumar, which went in appeal and appeal also confirmed.
Yes.
Identical matter.
Yes.
Under the Karnataka Universities Act. Do you have that judgment? Extensively, it has covered almost every aspect of the doctrine
We
of
have
pleasure.
relied
etc.
upon judgments, Lords, not of His Lordship Justice Arvind Kumar. I'm sorry, but the other judgments we have. I'll just point out those things. If my lords are to see section 19(1), Lord, subsection D. The following shall be authorities of the university, namely clause D. 3 represent, sorry, I'm sorry. But this empowers the state government to nominate 3 representatives of the government of Karnataka nominated by the state government, one of whom shall be director of technical education. Now, my lords may also kindly seek subclause 4 now, the tenure of these members. The term of the members of the executive council other than the ex officio members shall be 3 years. But in exercise of this power, I was appointed for a period of 3 years on 23rd March 2023, which is at page 63.
The 3 year is not over.
Not over. The reason for my removal, Lords, is something very interesting. I must bring to Lordship's notice. On 25th of May, Lords, 22nd of May for that matter, there was a change of political dispensation in the state of Karnataka, pursuant to which a general order came to be passed, stating that all appointments, nominations made to every university shall stand annulled or shall stand recalled. Not kindly see page 63. Page 63, may I request Lordships to kindly peruse. This is the English translation of the Kannada. Page 63. 63. In connection with the public universities coming under higher education department, in exercise of the power conferred under the Karnataka State Universities Act and other separate acts, the Karnataka government has ordered with immediate effect to cancel all the non-official member nominations made earlier till date 22/5/2023 to the syndicate, executive council, executive committee, managing board, government meeting, academic council, Pratikshana council, authorities, and all the non-official members made to the Karnataka Higher Education Council under section 3(6) of the Karnataka State Higher Education Council. All the non-official member nominations made to educational institutions established in public universities, and all the non-official members nominations made to the Board of Governors in connection with private universities coming under the higher education department. But this is the premise or the foundation on which my nomination also came to be, or appointment came to be recalled by the Vice Chancellor. Now, under the Karnataka, that is University Act.
By the Vice Chancellor?
Yes, Lord. That Lordships will get it at page, removal, Lordships will get it at page 74. Huh? 66, I'm sorry, 66. 66, may I request, Lordships?
Only consequential order.
This is a consequential. Now the question is this, but I may bring to Lordship's kind notice the question of law, my lord, which was extensively argued before the learned single judge and in other connected petitions also. The chief argument of the respondents, the state, has been that this is a case of withdrawal of pleasure, and therefore we need not assign reasons. This is a case of not appointment but of nomination. That is the subtle distinction they propose to make, and say therefore that since we have withdrawn the nomination made by us in exercise of our powers under section 21 of the General Process Act, the order should stand sustained. Lord, the law, Lord, my respectful submission to Lordships is stands settled by the judgment of the Honorable Supreme Court in BP Singhal's case, where Lord, their Lordships were considering the high office of governor's appointment being withdrawn. But there, my lords, according to me, this is the position.
Constitution.
I'm sorry.
That was under Constitution.
Under the Constitution, but their Lordships essentially lay down the what should be the mode and method of exercise of pleasure theory, my lords, and how should the court?
First question will be whether in the teeth of 1904,
yes,
there is scope for pressing into service the doctrine of pleasure.
Yeah.
That is number one.
Yes.
The second question would be, since ours is a limited government contemplate ordained under the Constitution,
yes,
to use the words of
yes,
Vasu, whether that doctrine has been exercised, power under that doctrine is exercised reasonably.
True.
These are the two questions. The judgment which you mentioned is of the Constitution bench judgment, where the power of the government of the day to recall the governors, that was the question. That was under the Constitution.
Yes.
Generally, where doctrine of pleasure would generally operate. That's the view of
Yes.
many scholars, including Dr.
Yes.
Ambedkar ji also. But question is, in the light of
1904,
1904,
yes,
whether there is scope for invoking doctrine of pleasure by the state or not is the first.
Lord, that is the first principle,
First
Lords, on which it has been canvassed. In fact, Lord, I must also point out the only method of vacancy under in respect of these things are provided under section 47 as to how an office of any officer is vacated. Two situations are contemplated. One is resignation, another is, Lord, if he is
No other
convicted in
mode.
court of law. 47.
Resignation and
Resignation, and if he is convicted in a court of law for
removal.
Yes, sir. These are the only two situations contemplated. I would wanted to point out something before you.
47.
Lord, I make one submission, my lord. My lord, I apologize. My lord, I forgot to intimate the learned advocate general that this matter is there today. My lord would have it on Monday, my lord, a short accommodation. I apologize, my lord.
The
One day.
I have no. If the learned advocate general is making that.
The meanwhile, bring that.
Yes, but Justice Arvind Kumar.
Justice Arvind Kumar's judgment, Dharwad, while he was sitting in Dharwad.
Yes.
Lord. Otherwise, it would become department of the government, is your.
Yes, ma'am.
Autonomy will be lost. And many
But the,
decisions.
of course, but this,
So how much, how long you hold the office?
I would have it from up to 2026
You are supposed to be there at 226.
to 2026.
Nominated when?
23rd March 2023. For a period of 3, and well, they are all professors. They are not what's, they are all professors who were.
So your nomination depends upon some other capacity?
No, there is no
Only-
qualifications as such what's prescribed under the Act. No qualifications are prescribed under.
So sometimes these nominations are drawn from some representative capacity. Is it not that?
No, it is not so. It is at the.
Your capacity there as a.
No, not ex officio. This is not ex officio.
Not ex officio.
It's not ex officio.
Ex officio again a different.
No,
name.
ex officio is
Different. This is not ex officio. I'm not drawn from any.
Simply all of a sudden this notification.
Yes.
The state government chooses first and then nominates.
I apologize once again. my lord.
Doesn't-
It's my
Monday.
obligation.
How other high courts in their statutes have held.
Lords, I have relied upon all of them. One is the Bombay judgment, wherein they have said there is nothing like a doctrine of pleasure. They go to the extent of saying insofar as these matters are concerned. But may I, Lordship should permit me, there is a compilation of judgment with, if Lordship permit, I'll place it before the court officer so that it will become easy.
If possible, 2 dates.
Right now, I will put it, the paragraphs, relevant paragraphs I'll call out.
Give to the other side also.
Yes, but I'll serve it up.
Share one copy.
Yes,
Sir,
certainly,
also.
most. But I will call out the relevant paragraphs so that it should not be burdensome for Lordships to go through the entire judgment along with the main judgment.
Yes.
Number 21. Maya Tara BG.
Your lordships have stayed the same impugned order in another writ appeal, my lords, I may be permitted to place that on record.
Stay ಮಾಡಿದ್ರು. Issue notice. Same issue.
Please, my lords, same impugned judgment has been stayed, my lords.
Stayed also.
Please, my lords, in WA 130, I may be permitted. Writ appeal 130, my lords.
Writ appeal one.
In another matter.
Please, my lords, I have the copy. My lords, this is writ appeal 130 by order dated 22/2024 on the IA, my lords. There's an interim order insofar as the petitioners are concerned. My lords, the petitioners are none other than the persons appointed under this notification.
Stay has been granted in other connected matter. I was only mentioning to Honorable Chief Justice that you have written best articles.
I'm deeply
Several
obliged, my lords. I'm
topics.
so grateful.
It's a good habit.
Same judgment is stayed.
Same
Pardon?
judgment.
Same judgment
Please,
is.
please.
So heard, learned, Advocate Miss Nayana Tara, PG for the appellant, and learned advocate Mr. So for the case one number.
My lord, AC Balraj.
You are for
Yeah, respond number 1, my lord.
one. Notice to others.
Notice to the rest of the respondents returnable on 24th of April.
Yep.
Since other matter is coming up.
Very well, very well.
24th of April. It was undisputedly stated that in writ appeal number 130 of 2024, the same judgment is under challenge, and that this court has granted stay of the judgment. In that view, the said stay order shall apply to these proceedings also,
Please, my lord.
to operate during the pendency of writ appeal.
Please, please. I'm deeply grateful.
This is number 22.
Lord, I appear for the
Prabhakar.
appellate. Lord, this is a matter arising under the Provident Fund Act, my lord. What has happened, my lord? My statutory appeal was pending before the Provident Fund Appellate Tribunal. Interim order was granted by the tribunal, my lord. Afterwards, my lord, the union filed an impleading application. It was between the Provident Fund Department and me. 7-year order was stayed by the tribunal, PF tribunal. Thereafterwards, my lord, the tribunal became vacant as on today, my lord. Your lordship are also aware of that fact, my lord. Then, my lord, they approached this honorable court by filing a writ petition stating that interim order was not extended. Therefore, that order 7A, which is the subject matter of the statutory appeal, has to be implemented, my lord. Then, my lord, the learned single judge passed an order. May I read that, my lord, page 16, my lord. May be permitted to read this, my lord. In fact, my lord, the Provident Fund Tribunal Council conceded that point. Since the appeal is pending before the statutory appeal, the tribunal, we do not want to wish to initiate any recovery proceedings based on the union's plea, my lord. The learned single judge has ignored this and passed an order giving the direction to the department to take action when the statutory appeal is pending. My lord, may I kindly see the last operative portion of the order, page 17, my lord. I find no justification in the submission made on behalf of the first respondent, that is Provident Fund Department. The records are secured. A perusal of the same would reveal that after 19/3/2020, the interim order is not extended. Therefore, this court deems it proper to quash the annexure, quash the letter dated 19/5/2021, my lord. My lords may kindly see 19/5/2021 letter, my lord, which is at page 53, my lord. Annexure B. My lord, this is the letter written by the department to the union stating that we cannot implement the order because the appeal is pending, my lord. This order, this is a letter written by the department to the union. How the learned single judge can quash this order, my lord? They quash this order, my lord. This is a letter. This is not even order.
Where is that page?
53, my lord, Annexure B, typed copy. My lord, by virtue of this quashing of this order, Annexure B, my lord, what has happened, my lord? The department has issued me 14B notice when 7-year proceedings are pending before the tribunal. It is virtually interfering with the tribunal's power by the High Court when the court is also vacant and interim order was in existence, my lord. Therefore, gross injustice has been caused to me, my lord.
Employees. Act. Employees Provident.
7A order has been challenged under 7I, my lord, before the Provident Fund.
Original order is passed under which section? Original order is passed under which section?
Original order under 7A, my lord.
7 capital A.
7 capital A by the authority, my lord. Then again, as that appeal lies, my lord. I hope, my lord, your lordships are aware of it. The Central Administrative Tribunal is not functioning for the past 2.5 years. Not functioning, my lord. And therefore, there was a writ appeal, the writ petition was filed.
No, not correct.
Yes, my lord.
Justice Sujata is posted.
No, I'm sorry, my lord. Central Industrial
Oh,
Tribunal,
Industrial.
Industrial Tribunal, which is also this thing, the Provident Fund Appellate Tribunal. I correct myself, my lord.
7A order is put in challenge.
Put in challenge, my lord, before
The appellate authority.
appellate authority.
But there is no functioning hand.
From your lordship may kindly see page 201, my lord. The tribunal passes an order. Interim order is extended from time to time. And afterwards, my lords, the Justice Ratnakala was the presiding officer. My lord, she demitted her office and no officer is posted from 21 to 2024, my lord. Then, my lord, interim order, which has already been there, it cannot be denied to me merely because it is not extended, my lord.
Today your appeal is pending
My appeal is pending, my lord.
against order passed under section 7A.
Yes, my lord.
Now what is page 53 now? That communication annexure.
53 is the communication given by the department that we cannot implement the order because appeal is pending. When they themselves concede, the learned single judge erroneously passed this order, my lord.
Whose appeal is pending?
Their appeal is.
My appeal is pending, my lord.
Appellant's appeal is pending. This is question. This is intra-departmental communication.
Well, it is only a communication, my lord. And the department,
So this is cost. But then what is the effect on your?
they have given 14B notice, my lord.
Heard learned advocate Mr. Francis. Mama.
Any panel counsel is there?
Yes, my lord. I may be permitted to serve on the panel counsel who appeared before the learned single judge.
Excelling the judgment and order of learned single judge passed in the writ petition whereby learned single judges set aside the communication dated 19/5/21 into bracket copy of which is produced as an Excel B bracket work, which is an which is a communication intersect between the departmental authorities. Full stop. So stated that the against the order passed under section 7 capital of the Employees Provident Funds and Miscellaneous Provisions Act 1952 from appeal of the appellant is already pending before the appellate authority. It was further submitted that the setting aside of the aforesaid communication will render the appeal infectious as the order will be enforced against the employees. The ground is made of admission of the appeal.
Notice has to go.
Delay.
There is a delay, my lord.
So notice written.
Much of.
We'll keep it on which date?
You need date, my lord.
2nd of
April.
Lord, I may be permitted to serve the notice on the council who is appearing.
Permission accorded to learn and advocate. Then to serve copy of the appeal memo. Appeal compilers. Learn and advocate for the response. Who appeared before learners.
Before the learners. Much of.
On what ground it is set aside?
Lord,
On that day.
Number 23, Mr.
appear for
P.D.
the
Surana.
This was a matter pertaining to the award made by the Fiscalation Council at Annexure D. Now, At page 83, madam, one of the precondition of maintaining the application is that the supplier must be the manufacturer of goods. To maintain a claim petition before the Facilitation Council under MSME Act, the supplier must be a manufacturer of the goods which are falling within the Schedule 1 of the Industries Development Act. Now, the order does not relate to those goods because it is the upgradation of the ticketing machines and supply of the identification cards, which does not fall within Schedule 1A of the Industrial Dispute Act, Industries Act.
Industries Act.
Industries Act. May I pass on the
Both
schedule?
are central acts. Both are central acts. This,
The other thing is,
micro
yes, he must be a supplier,
MSME.
MSME.
You had challenged provisions.
Provision also on the ground that there is no judicial member comprising this adjudicatory body.
Therefore, act becomes bad.
Therefore, my submission is, I cited a judgment of the Honorable Supreme Court. In the case of the R. Gandhi, I have produced a judgment also, that when the judicial function is entrusted, the body should consist of judicial members. Because it is a lease is to be decided without judicial members. Kindly turn to may request the Lord to kindly turn to paragraph 90 of the judgment of the Supreme Court at page 184, my lord.
Which section provides for establishment of adjudicatory body?
Yes, section 20, my lord.
20 of MSME.
MSME.
Does it not provide for arbitration? MSME provides
First
for
is,
arbitration.
the first they have to take up the conciliation, and if the conciliation fails, then they have to go for arbitration.
Correct.
In this case, they did not go for arbitration, but straight away they passed the award without recording evidence, without anything objection, no evidence is conducted. Totally an award is made with contrary to the principle of natural justice.
You challenged what all provisions of the.
No, I challenged the 19 to 24, but I confined my challenge to section 20.
20.
20. Constitution of the.
Read.
Section 21. The
21.
composition of the Micro and Small Enterprise Facilitation Act. No judicially trained members are there.
Why that, see, 21(4).
21(4).
Huh. Clause 4, 21(1)(4).
4 I don't have.
21(1)(4) says one or more persons having special knowledge in the field of industry, finance, law, trade and commerce.
But the present council which was constituted which adjudicate matter, there is no judicial member at all. Trade and commerce is different from law. See, virtually the jurisdiction exercised by the civil court is transferred for recovery of money for the goods supplied.
No, why do you say that the section itself provides for appointment of a person who is having standing in law?
But the present council which is constituted does not have any member.
It's all right. But that will not cast a shadow on the constitutionality of the section.
Now, my submission is, now the members are constituted. I have called out the members which are constituted. There is no person having
That constitution, why can't you understand a small question? Let us try to understand together first. Suppose the Industrial Disputes Act provides for establishment of a labor court. Instead of a person having expertise in law, some dancer is appointed to the tribunal. Whether that will affect the validity of the legislation?
The question is,
Constitution of the body may be affected.
yes, constitution.
But how that will cast a shadow?
The constitution
on
of the body is affected. That is true, my lord. But there is no prescribed qualification which must be there. You see, qualification must be there. No qualification is prescribed as to
That
what
can
is
be-
the training.
That can be a case for co-warrant too. But how it can be ground for invalidation of the act itself?
The present constitution of the council which was made.
That you could have challenged.
Yes, that is.
But
that
how
is-
act your virus
That
of
is,
the act?
that is one of the ground to quash that.
All right, then other grounds are?
Other grounds are the award is made without even hearing the matter. Kindly see annexed D, my lord,
That is made under which section?
under section 19. There is no person trained under law is appointed. Eighteen. 18-1, 18-3. So, there is no selection process also.
Section 18 was interpreted by Bombay High Court and by Kerala High Court. Do you have those judgments?
I don't have the Kerala judgment, but the judgment of Gujarat High Court I have produced. That the judgment says that a supplier must be one qualified under the act. Now here is a case where the supply relates to the goods which does not fall under the Industries Act. Goods which does not fall under the act. Under the Schedule 1 of the act.
Of which act?
Of the Industries Act.
Industries Act.
Yes.
Which provision of MSME Act relates to Industries Act? Why are you taking us to this first schedule of the Industry Development
Yes,
and Regulation
that is-
Act 1951?
Kindly see section 2E
of
this act. I have extracted page para 11 of my petition, rate of bill.
Of Industries Act?
No.
MSME Act.
MSME Act 2E says a enterprise means two E.
2E.
2E. I have extracted 2E at para 11. Two enterprises means industrial undertaking or business concern or any other established by whatever name called, engage in the manufacture or production of goods in any manner pertaining to industry specified in first schedule to the Industry Development and Regulation Act 1951, or engage in providing rendering services or goods. Therefore, it is only a person who manufacture the goods which are mentioned in Schedule 1 will fall within the definition of the act.
Otherwise, you will not,
He will not
answer the definition of enterprise at all.
And it must be a micro or a small enterprises. For that, they have to obtain the certificate from the Udyog. Even the rules require that the Udyog number must be attached.
How this argument is considered by the learned single judge?
The learned single judge did not refer to all that.
Not referred at all.
Not referred to.
Any
Though
high court has considered?
Though I have quoted all these sections and he has referred to the sections, but he did not dealt with it all.
In other words, what you want to say is, unless it is an enterprise as defined under 2E, it will not, the act itself will not be applicable, is your contention.
Yes.
Where is the ground we have taken that?
Yes.
In the writ petition?
Para 7, page 54.
No.
Para 7, page 54.
There
Yes.
is nothing like that.
Any enterprises engaged in the manufacture of goods. Para section 7(1)(a)(1) of the Micro, Small, Medium Enterprises Act defines micro enterprises where investment and plant machinery does not exceed 25 lakh. Section 7(1) Micro, Small Industries engaged in definition where the investment in plant and machinery exceeds 25 lakh but did not exceed 5 crore. In enterprises engaged in manufacture of goods or engaged in services as required to file a memorandum before the authority constituting central government. Such authority, after following the procedure, has to classify the enterprises as a micro, small enterprise. The status of the industrial micro, medium enterprises has to be considered by the authority constituted in section 8 of the Act. The only enterprises which has filed such memorandum is entitled to invoke the provisions of the Act for the recovery of money in respect of the goods sold and supplied to the buyer by invoking the application by Collection Act. Section 8 provides that
No High Court has decided this aspect of the matter? No other High Court?
Gujarat High Court has said that, kindly turn to page 283.
283.
Paragraph 50 and 51.
Bombay High Court judgment it. Justice Kulkarni. But
they refer to section 2N.
This entity was registered as MSME.
Please,
No.
even,
It was
I am the, I appear for Union of India, but respondent number 1 was registered, award was passed, award was challenged before the Honorable City Civil Court, my lords. There they were required to deposit 75% of the amount, which they did not do it. Therefore, that appeal came to be dismissed. Even that order was challenged before the
By challenge
single judge, among other reliefs. Already
have
there was
state-
a award, my lords, in favor. Unless they have registered, my lords, award won't be passed by the authority, my lords, under the MSME Act.
Which second respondent?
I
Yeah,
appeal for
no,
the second
in fact,
respondent. It's the first respondent is the private respondent who was registered under the MSME Act, my lords. Annexure F is the order at page 101, 106 is the relevant page wherein it was dismissed.
Yes, that is true. I have-
Dismissed in the sense, my lords.
That is also a challenge.
To deposit the amount of 75% of the award amount within 15 days, my lords, which they did not do it. Page 106.
This award passed will be treated as an award passed under the Arbitration and Conciliation
Please,
Act.
please.
only.
So it will not work with that.
Huh?
It will not work because only in section 34 does not provide for modification of the award by the civil under section 34. It only can either set aside the award and dismiss the petition. Therefore, it will not merge with that. Therefore, I have also challenged that. Now, kindly say.
You are not answering, you are not grasping the question of the court. That's the problem.
Yes, madam. I'm sorry, madam.
Please listen to us attentively. Whether the ground which now we have urged before us could be taken for invalidation of the award by a challenge laid under section 34 is the question. That will be, read section 34 of the Arbitration Act. Because Arbitration Act is incorporated here under section 18.
Please, my lords, if my
18.
lords, if my lord sees even page 102 of the paper book, my lords, the issue which fell before the honorable court was whether the appeal under section 34 of the Arbitration and Conciliation Act is maintainable without compliance of section 19 of the MSME Act 2006. That was the
question.
Because the
considered.
constitutional validity was challenged. I also challenged that order also.
No,
The
is
question-
it, whether your proposition is the ground on which you have structured your petition, writ petition, and now writ appeal. That cannot be a ground that would fit into the precincts of section 34 of the Arbitration Act. Therefore, we requested you to read arbitration section 34 of the Act. Because Arbitration Act is incorporated.
Now, so far as the section 34 petition is concerned, it is disposed of as not maintainable.
No,
Because
but we want to know.
Yes, that can be, that's one of the ground also.
You have objection for our knowing this also.
That is one of the ground can be there also.
Read
Now
section
that-
34.
34,
Application for setting, ಕೊಡಿ ಅವರಿಗೆ, ಇದನ್ನೇ ಕೊಡಿ.
May I
We have
read?
Arbitration Act.
Please, my lords.
Why lawyers are coming without statute books? Have you ever seen any farmer going to his field without the agricultural implements?
My lords, we are using the whatever. Notwithstanding anything contained in the Arbitration and Conciliation Act 1996, any dispute or differences arising between licensee or in respect of matters specified in the subsection 1 of.
So it is incorporated. Act is incorporated. All right. So go to section 34 of the Arbitration Act.
Please, my lords.
Recourse to the court against the arbitral award may be made only by the application for setting aside the award in accordance with subsection 2 or subsection 3. An arbitral award may be set aside by the court only if the party making the application establishes the basis on which the record of arbitration. A party was under some incapacity, arbitration agreement was is invalid. The party making the application was not given proper notice of appointment to arbitrator, or the arbitral proceedings are otherwise unable to present his case, or the arbitral award deals with dispute not contemplated or falling within the terms of the submission to the arbitration, or it contains the decisions on matters beyond the scope of submission to arbitration. For the decisions on the matter submitted to arbitration can be separated from those not so submitted. Only that part of the arbitration award contains the decisions on matters submitted to arbitration to be set aside. The composition of arbitral tribunal or the tribunal procedure was not in accordance with the agreement of the parties, unless such agreement was in conflict with the provisions of this part, which the parties cannot derogate, or following such agreement was not in accordance with the first part. The court finds that such work matter of the dispute is not capable of settlement by arbitration under the law for the time being in force. The arbitral award is in conflict with the public policy of India. Now, the question of jurisdiction can be gone into at any stage of the proceeding further.
No, the court section 34 court did not deny you relief on merits, it said you did not
Deposit the amount
abide by the condition,
of 75% deposit.
therefore, it has
No,
happened.
therefore, see, in view of the fact that the facilitation council which was constituted by the state government was not in consonance with the constitutional requirement, the act was challenged.
Did you take up that contention in the arbitration
In the
before the initial authority?
34 is what?
Huh?
30, see, for the purpose of filing the objection, arbitration proceeding itself did not commence.
Did you take up that contention, this contention which now you have urged before the section 34 tribunal?
Yes, we have said that the proceedings are not maintainable.
To examine that contention, court had put you on condition. You should have abided by condition. You are not some Ramegoda, Bhimegoda who was not in a position to deposit. You are an institution.
Yes, true, my lord, true. The writ petition was filed, and the challenging the validity of the act. My submission is,
2018 DB. Dr. Vijay Malya, judgment ILR 98.
may I read one provision, section 90, para 90 of the judgment of the Supreme Court.
That's all right. Court did not deny you relief.
Now,
It
under
had
section,
put you
when I file
on
a
condition.
petition, when I file a petition of section 34, I can't challenge the constitutional validity.
That's all right. That we will not,
Therefore, writ petition was filed.
we will not go to that because where examining constitutional validity becomes inevitable. See what Sirvai has said in fourth edition. The court shall not undertake examination of constitutional virus of a statute or any provision thereof unless it is essential for adjudication of the lease at hands. Now, you had approached the tribunal. Tribunal said, we will examine your contention, provided you do certain things. That you did not do. Now, why we should at all consider?
Now, question, my submission is, if the arbitration proceedings were taken up by the council, I can understand it.
That all
No.
contention goes to merits. All
No
that is being
arbitration-
examined.
No, it is an award which is nullity in law.
Therefore,
it can be set up on any, even collateral proceedings that is nullity in law.
but you have not done that. You have challenged it. Why did you go to challenge?
No, the challenge was made, therefore I came before the Honorable Court.
You should have,
Under 226, sir.
Your,
Under 226, sir.
Your contention runs counter to constitution bench judgment of the apex court reported in 1992. 1992 SC page 111 paragraphs 5 and 6. Read that judgment. Let him read loudly. Supreme Court.
That can I have it next week? I'll go through that.
I will make you read. I will give that judgment to you.
I'll read it with leisure instead of hurrying through it.
You are structuring your contention on the basis of perhaps, which you are not quoting, I am quoting, 1954 Supreme Court 347 or something like that. Kiran Singh versus Chaman Paswa. That we will loosen now. Read this judgment. A decree passed without jurisdiction is a nullity, etc., etc. Very rhetoric judgment was made. Now kindly read this. Court, after referring to Wade and Forsyth, they have said
54 SC 340 minutes.
correct.
340.
340.
Number of judgments are there.
That has
Thereafter
been,
also.
that we will loosen now.
No, thereafter
That
also. Thereafter also 2016-11.
Why can't you read when court requests you to read a judgment? Good lawyers will generally read. The apex court referred to Wade and Forsyth on administrative law and said, an order without jurisdiction, though is a nullity, it does not have brand of invalidity on its forehead. This is how the judgment runs. Therefore, An order which is ostensibly in a nullity will have capable of legal consequences unless right person lays challenge in a right way before the right forum and in the right time.
I will just
It's nothing.
kindly have it next week, my lord. I will just go through it.
Not comply with the condition. Right? Don't say.
75.
You pay, we'll examine. It is always possible, right, from 53 Supreme Court.
So that is a condition
There
section
is a
19
condition
of
that
the.
is there.
Kindly, I will place all the judgments.
Don't hear it that way.
I have also collected the list of judgments on the question nullity. I will place them.
That's pretty, we'll consider.
I have.
No date will be given that way. We don't decide the matters on installment basis.
Such sections are already applied.
Nothing.
You have deposited 75%.
No, he did not.
No, they are not deposit. On that count only it was dismissed.
So how the 35 proceedings were initiated?
So there was a award pass.
Kindly.
He should have abided by the condition which the tribunal, the section 34 court had said. He did not do.
There is, he held.
That is also one of the
34 you held.
Yes.
34 was filed, it was challenged, it is also one of the challenge.
There was a
because of the-
condition.
65%.
No, no, make my submission. I have also challenged that order of depositing the amount.
No application setting a decree or made to council entertained by the court. So it will get to 34.
The conditional order was made on 22nd of March 2016, my lords, to deposit 75% of the percentage within 15 days.
Correct.
That they had not done it.
Or held similar condition in Vijay Mallya versus Kemp, held with the expert, where an authority imposes a condition to appellate.
Medical submission.
It's not that the JP is a population. Some poor person we can understand.
May I request me to have it next week?
Vijay Mallya versus Science. Constitutional. Says. Unless it is most essential for a judge.
I will pass on, I compel the judgments and give it, kindly have it next week.
Like that.
Okay,
how long we can go and argue in this matter?
No, no, only on the question of jurisdiction.
You have
On the
said,
question-
you have argued the propositions. Every proposition will be jurisprudentially treated by us.
No, no, the question was right by the court. I did not go through this 92 Supreme Court. I will just place the other judgments on the record. Have it kindly next week.
We refer to 1992, not 2022 judgment.
No, no, thereafter, number of judgments are there. I'll place on record.
This judgment is also reiterated.
That is true, my lord. I will kindly have it next week, my lord. The supply did not relate to the,
Why did you not comply with the condition which section 34 court?
no, that was also, that was because of the ground rise, therefore I did not, I will come now. Give me the liberty, I will comply with the proceedings.
But you should have done that time, not
No,
now.
that is also one of the matter, one subject matter here.
If you were to be a poor person, perhaps we would have maybe the Jolly George jurisprudence would have come to your aid. You are a corporation having property worth several thousand crores.
It is in debt, sir. There is now shortage of money even to pay the
That was not
salary.
the ground. You have not taken up that contention in all of the writ petition, that we had no funds and therefore we are not in a
No,
position.
that's
to-
not, no.
That's not
My
the-
submission
it's
is,
only
now,
argument
that is
in,
because even the proceedings of the 34 are also the subject matter petition. Permit me to deposit 20%, I'll do it.
Now, this order is also challenged.
Yes.
That if this order is, this prayer is rejected, then the other prayer will not.
now he is saying that we make that deposit.
Then also, then that is covered.
Kindly bear in mind, the manner in which the award is personal.
My lords,
That question is section 34 precincts.
That is
We
true,
do
my
not
lord,
do.
but see, that though the 34 remedies available.
What do you
if-
say
if
about
prima
this
facie-
proposal?
Lords, appeal is filed in the year 2010, my lords. Order was passed in the
kindly
year
see.
2000.
When he is speaking, we have heard you. Yes.
Lords, section 34 appeal, my lords, is filed by the appellant in the year 2010. After that application is 2010, they have filed. my lords. AS 92 of 2010.
The award was made on which date?
Lords, award was made on
16th August 2010.
16th August 2010, my lords.
16/8/2010.
Please, lords.
When it was served on him?
Within
begins after
limitation.
90 days is the limitation, my lords.
That arises, Apex Court said that arises after service of the award,
Please, my lords.
not before that. When it was served. When it was served on you, Mr. Surana,
Like it was filed within limitation. I don't have the date when it's served, but the petition was filed.
it was filed within
30
Within
the
time, my
limitation.
lords.
Within
At
time,
ever-
34.
Within,
All right.
within time.
Now he is saying that I will make deposit of that 75%. You set aside this order and remand the matter for fresh consideration. Whatever the other side has to.
my lords, is the other side which has, but it is after 24 years, my lords, they have suffered for 24 years.
You are not.
What is the
Not
amount
the
involved?
party.
What is the amount involved?
Lords, it's
See,
69
amount
lakhs,
is-
my
No,
lords.
no, amount is determined.
69
without-
lakhs,
no, amount-
45,901.
Kindly see,
We are asking you some arithmetical value, not the process as to how that value is arrived.
64,
69 lakh-
no, 64 lakhs, 69 lakhs, 45,091.
About 70 lakh rupees in 2010.
Please,
Any interest is ordered?
No interest is on.
with 6% interest. my lords.
6% interest is ordered. So 10, 22, 100 or less. Around another 72% of the amount will be added to that. About 70, another 49 lakh would be added to that arithmetically.
See, if the determination is there, my lord, absolutely, absolutely there is no determination at all. Kindly see the award, my lord, at Annexure D. Have a look to it, my lord.
We will not examine that because there is a statutory body which the parliament in its wisdom has constituted. That body will have jurisdiction.
Very well, my lord, permit me, I will deposit, my lord. It is the time fixed by the court. Whatever the amount my lord wants to fix, I will deposit.
You should have done it. You are not some layman or something like that.
Allah, kindly give me that liberty of depositing.
Every argument we'll consider.
Liberty for what?
I will deposit the amount and proceed.
We'll be doing a very dangerous precedent. Tomorrow, all MSME people will come with this judgment.
Allah, as a one-time measure, my lord.
That becomes a precedent for rest of the people.
Allah, that may be observed.
We can't say that.
Allah, it's only after my submission is, if there is adjudication is made, I can understand it. There is no adjudication at all.
Sorry. Dismissed.
Dismissed.
The latest judgment is of Supreme Court 2006-11 SCC 245, para 61 minutes.
Every judgment we look after, provided you have maintained the protocol. Supreme Court said how judgment should be cited. If you have done that, we'll consider.
Number 24, NS Vijayant Babu.
My lords, I appear for the appellant. Appellants, my lords, is questioning certain observations made against it in the judgment passed by the learned single judge. My lords, going to the facts of the case, my lords, appellant is one of the successful bidder in the tender invited by the respondent BBMP for carrying out solid waste management related activities in the year 2019. It is for a period of 1 year. Thereafter, he was being issued extension work orders from time to time. The latest order is at Annexer H, issued in the month of September 2023. My lords, the agreement we have produced at Annexer C, it lays down, it enumerates at 10.1, 15 events of default, in the event of which a termination notice can be issued. The procedure for issuing termination notice is given in 10.3. First, a preliminary notice should be issued saying that which of this default he has committed, with a 15 days of curing period. And if he doesn't cure the defect within that period, then final termination notice has to be issued. This is the procedure laid down in the agreement. My lords, from the past couple of years, what is happening, my lords, because of the interference of certain councillors and corporators, the work orders are being abruptly cancelled without any reason. My lords, my lords may kindly see page 109, Annexer L. This is an internal circular passed by the BBMP itself, pointing out the issue. This issue, my lords, page 110, English
So
translation.
it was a very, very preposterous and speculative litigation prayer.
My
No
lords,
notice was issued to you saying that we are going to terminate it.
My lords, I'll come to that. My lord. My lords, may for a moment kindly see page 110, my lords. May I read this only one paragraph. Regarding continuation of the contracts of solid waste management service providers till the completion or the tender period of the tender period. In reference to the above subject, it is true municipal solid waste generated within the jurisdiction of the Palika is being managed through the contractors. It has come to the notice that in few words, again and again, the contractors are being changed. Due to changing the contractors again and again, municipal solid waste is not being effectively managed, and in this background, and also because new solid waste management tender is in process, in the interest of public, until the new tender process is concluded, it is suggested to continue the contracts of the existing service providers. My lords, subsequent to this, at page 111, Annexer M, my lords, on 29/12/2021, a high-level committee meeting was held by the BBMP involving all the top officers. My lords, the translation of relevant portion is at page 116. My lords, this meeting was held to address the various problems being faced by the service providers. These are the proceedings of the resolutions made upon discussion in the meeting held on so and so, in the conference hall at so and so, my lord, to address the problems being faced by the service providers.
Your tender contract.
Tender contract.
Yes, ma'am.
Is it over or still continuing?
My lords, it's still continuing. After passing of, after filing this writ petition,
Extended.
it's extended.
Extended.
Extended until the new tender concludes.
It is extended or original period is continuing?
It is.
Contract period is continuing as it was granted originally, or it is extended?
No, contract period in the year 2019 was for a period of 1 year. Subsequently, from time to time, they're extending it. Last extension is in September 2023.
The process is not being undertaken. Therefore, the meeting was held.
September 2023 Annexure H is the last extension given to us. My lords, in this Annexure M, may I read one paragraph, my lords, which would throw more light on the situation which is actually happening now, which is
All right.
causing.
Accept the notice.
Correspondent number 1, ma'am.
Who was the lawyer who appeared for BBMP in the court before the learned single judge?
My lord, it is Pawan Kumar.
Pawan Kumar directed to take notice, accepts notice for our.
Notice written over 5th of June.
Pawan Kumar.
Who appeared for?
Respondent
Corporation. First respondent. First respondent.
Obliged.
25, the K.R. Krishnamurthy.
Lord, I represent the appellant's counsel. Lord, this was an industrial dispute raised under section 10(4)(e) of the Karnataka amendment. Lord, an individual dispute, which your lordship will find on page number 10(4)(e).
Reference.
10(4)(e) reference. Lord, upon completion of the pleading, your lordship may turn to page 55. These were the two issues the labor court initially framed, Lord. Three issues, rather. Page 55. Whether the first party proves that he is a workman, yes. And second, whether second party proves that the dismissal order dated so and so passed by second party is legal and justified.
Yes.
And what order? Lord,
then what happened?
Then an application was filed by the first party saying, please cast one more issue regarding the validity of domestic inquiry, which application comes to be allowed, which the order your lordship will get on page number 53, 2 pages before. That is the order of the labor court.
53
and 54. Order on I number 1. Point for my consideration, and then this is the order.
Another issue is
Yes,
framed.
another issue has been framed by the labor court.
Then what happened?
And not only the issue has been framed, that issue has been treated as preliminary issue. And the parties are directed to lead evidence on domestic inquiry. Lord, from the pleadings, it is nowhere the case of the first party or the second party that a domestic inquiry ordinarily understood, Lord, where an inquiry officer has been appointed and the parties lead evidence and an inquiry report obtained, and based on such report, the action is taken. It is nobody's case.
No, you are at the stage of this framing of issue. Why?
I am opposing, Lord, because
you wait, that issue may be decided in your favor.
No.
If it goes against you.
There is no inquiry, Lord.
Yeah?
There is no inquiry of the nature which normally is decided under this issue.
That's all right. But why on installmental basis management should drag the workman to the legal battle?
I'm saying all issues be tried. But the labor court is making installment now. And that order has been upheld by the learned single.
Correct. That's right. You can't, you could have waited till the award is passed. Then you can mount it the challenge with all the contentions for framing of issues 1, for framing of preliminary issue 1, deciding preliminary issue 1. That is not the procedure.
Lord, I did not do.
They have done, but you should not have come to court.
No, Lord, it affects my rights.
No.
There are two judgments which I must, your lordship must be aware. One is, which was a judgment of the year, Lord, in Cooper Engineering,
We
which
are
was
asking, we'll come to that. We are asking simple question to you, Mr. Hegde. Suppose if the award was passed after considering all these things, could you challenge the award on all these grounds or not? Supreme Court said yes. Therefore, why at every stage court should interfere?
Lord, my submission would be, by asking me to lead evidence or participate in a trial on validity of domestic inquiry.
He could have done after serving order 43, order 23, rule 1A is amended. 43 1A of CPC is held to be applicable to the labor court proceedings also.
True, Lord.
Single judges reserve liberty.
That's what. What is the wrong in this order?
My Lord may kindly.
Forget all arguments, learn a single judge reserve
Liberty to you, to everything. Then come afterwards. All contention.
Lord, my fear is not that, Lord. My fear is, Lord, which is contained in the observation made by the learned single judge. Please turn to page 28. Lord, this is based on Cooper Engineering, Lord.
28.
Page 28.
Yes.
It is para 15, Lord. The para 15 starts from page 27. Your Lordship may kindly go to page 27. It is well settled that the question of domestic inquiry having conducted to be fair and proper is an issue which has to be first decided by the labor court, as when there is no domestic inquiry or defective inquiry, if admitted by the employer, there is no difficulty, but when the matter is in controversy between the parties, that question has to be decided as a preliminary issue, as on that decision being pronounced. Whether the inquiry held is not fair and proper, it is for the management to decide whether it will adduce any evidence before the labor court on perversity, victimization, and disproportionality. Lord,
You
that
invited-
observation, Lord,
Who invited that observation?
I did.
The court.
I did not invite, Lord. An application was made. Of course, this is a learned single judge's order.
Absolutely nothing in this case. And learned single judge has a reserved liberty. What
That
else?
is all.
That
Learned
is
single judge
everything
reserved
is-
Lord, may I make my,
Ways with us.
Lord, may I make my effort?
Every state, if we permit the management to come, that if
1023 is what?
Lord,
the issue. Additional issue.
Lord, I would raise a fundamental issue, Lord.
Prolonged litigation, so that the working class becomes vulnerable. It's not the object. The only object of industrial jurisprudence is to maintain the level playing field. Therefore, every state, they should not be permitted to come to High Court because they are employers.
Lord, I have not done that. Your Lordship may kindly turn to page 73, Lord.
Every page I come after reading all papers, so we don't have any other job at all.
Lord, I'm not
Every
imputing
page.
anything. Lord, your Lordship may kindly not make that observation. Lord, I never
You are
imputed
permitted to
anything.
lead evidence also on filing of application.
Whatever
No,
he
your
wants to
Lordship
do.
may,
You want.
your Lordship may kindly give me few minutes, Lord. I'll just point out one paragraph from the claim statement. Lord, it was nobody's case. Nobody has pleaded there was a domestic inquiry. Lord.
Realm of consideration. Now,
This is not in the realm of writ jurisdiction at all, because all contentions will be open to you. In the event award goes in your favor, no question of challenge, maybe the laborer will come. In the event it goes against you, all contentions which you are now taking up before the single judge and now reiterating before us are open to you.
Lord, I ask myself a basic question, Lord. For raising an issue, there must be pleading. Lord, it applies to labor, industrial proceedings
Always
also.
we agree, but not at this stage.
Lord, an issue has been raised which does not arise, Lord. That is my contention. May I request your Lordship to kindly bear with me for a minute and please turn to page
We
73.
are not on that, Mr. Hegde. We are on another point, the doctrine of level playing field. You are management and you will have resources at your disposal. What should happen to the poor laborer if he has to be called to High Court to defend himself in writ court, the labor court, in appellate court? He will not be able to prosecute his claim at all.
I'm not asking for a minute that this matter must be decided in piecemeal basis. That was not my intervention, Lord. An application comes to be filed. Your Lordship may kindly bear in mind the first party before the labor court and the respondent before your Lordships is an engineer. He had an annual package of more than 30 lakhs. No, I'm not going into that aspect at all. At the relevant point of time, he had that package. Not, we have raised a fundamental issue that he had supervisory and managerial functions. And therefore, he is not a worker. I have not told the labor court, please treat this as a preliminary issue and try it. I only said, there is a workman issue, the burden is upon him. There is another issue.
To overcome all such kinds of arguments, the Law Commission recommended, and based upon that recommendation, CPC came to be amended. Yes, Order 43, Rule 1, capital A. It is held to be industrial jurisprudence also. At least 3 high courts have held that way.
Lord,
I'm at every stage. It says, all orders which were adverse to you during the pendency of the suit need not be challenged when they are made. You will have full liberty to lay a challenge to the judgment and decree. And by taking up a ground that such and such orders ought not to have been passed. Read 43, 1 capital A. It is held to be industrial jurisprudence.
True, Lord.
Just have it for a moment. So that many youngsters will be in the court hall. They will be knowing that students are here. Order 43, Rule 1A is on the recommendation of the Law Commission. 43, 1A, perhaps. There is such a provision in CPC.
May I read?
Yes.
Where any order is made under.
Read heading also.
Yeah. Right to challenge non-appealable orders
in appeal against decrees. Read.
Yeah.
Where any order is made under this code against a party, and thereupon any judgment is pronounced against such party, and a decree is drawn up, such a party may, in an appeal against the decree, contend that such order should not have been made and the judgment should not have been pronounced. In an appeal against the decree passed in a suit after recording compromise was accepted. Therefore, all grounds which you have taken up to void the order by which another issue is being framed will avail to you when you suffer an award. Why preposterous challenge at every stage? That's not the object of constitutional jurisdiction. This is held to be applicable to Industrial Dispute Act, the industrial sphere, by 2 high courts. So that I think the latest version of O.P. Malhotra on Industrial Disputes Act.
Your Lordship may permit us to withdraw that.
That's the best way. Keep up all contentions open.
Yes.
Yes.
Your Lordship may make that observation.
Yeah.
Writ appellate 6 permission for the appellant, 6 permission to withdraw the writ appeal, permission is granted. Dismissed as withdrawn. At the request of learned senior counsel, it is observed that all contentions of the appellant management as well as of the workman will be open to be raised before the labor court.
And your Lordship may also issue a mandate, Lord, so that the matter be finished.
You may request
labor court.
Very good.
I don't know the pendency, Lord. Your Lordship may give a reasonable time, Lord. I don't want some very strict timeline, Lord.
We permit you to make a request to the labor court because Supreme Court said we cannot fix a timeline, the latest judgment.
Yeah, it is open for the management as well workmen to raise all the contentions available in law before the labor court.
Obliged.
complaints in contempt matter, still number 26.
I appear for the complainant, my lord. By an order dated 26/2, 4 weeks time was granted for compliance, my lord. This is a matter regarding issuance of Sagoli sheet. And since the committee had been dissolved.
The
my lord,
direction is to consider the application. We have filed 2 affidavits before this honorable court. In the first affidavit, we have stated, in pursuance of the order dated 9/3/2022. The application in form number 53 was placed before the committee. The committee directed to conduct a survey. We have conducted a survey on 23/7/2022. And again, it was placed before the committee. Thereafter, the committee was dissolved in the year 2023 because of the new government, the election and new government came into force. Now the committee is not
Working.
working.
Committee is
Formed-
not there or committee
Not
is
there, not formed.
Not there at all.
Not there.
not formed.
Not formed. As soon as the committee is formed, we'll place it before the committee.
When committee would be formed? Since how long it is not there?
23.
23? Since 2023,
2020.
it's not there. Period has expired, members' period has expired.
Yes, ma'am. Since the MLA is one of the member of the committee, now the new MLA has been elected.
That was more than a year has happened. 1.5 years
Committee.
happened.
It's only for the,
Whereas the direction is concerned, we have considered it.
At least you should say that committee will be constituted within a reasonable time and things will be accomplished. That's how the,
Instruction- Yes, I
things should
sought for the instructions, when the committee.
no, 2 affidavits you have filed now.
Yes, ma'am. That is for.
They come here not for affidavit, etc. They come here for some substantive rights.
I understand.
Where you said that the committee is not functional?
The second affidavit. Affidavit dated 25th September 2023.
In which paragraph?
Which paragraph?
Complaint was placed.
Para
before-
seven.
Para 7.
Para 7.
Para 7, page number 3, para 7.
Of the second affidavit?
Yes, ma'am. Affidavit dated 25th September 2023.
No, it's not there.
In para 5, we have stated it ceased to exist. In this regard, it is respectfully.
Cease it to exist because of.
Yes, sir. State Assembly election. And that in para 7, we have stated as soon as the committee is formed.
Committee is not constituted,
Yes,
Mr. Babu.
yes, my lord.
But that's not your prayer also to
No, no,
constitute
that
a
is-
committee.
that is not my prayer.
Therefore, within 6 weeks from the date committee is constituted, they should do that. That can be the best order we can
My
ask.
lord, correct. But
With that proceeding.
no, my only apprehension is indefinitely the committee,
No, that's not your prayer. That's not the mandate of the.
no,
that single
just a
judge.
submission, that's all. It's not my ground.
Therefore, we can say after the constitution of the committee, hopefully that it will be constituted before long. This
Yes,
matter would be
yes,
placed at the hands of. With that observation, we can
Yes,
dispose of the.
Yes,
Number 3 committee is same committee.
Same committee, but members are not. It's a statutory committee.
Here it is said grand committee, it is with Bharat, Babu. The contempt of court is alleged in this complaint in respect of direction of learned single judge in the writ petition number 19839 of 19. Was decided on 9th March 22. So the writ petition came to be disposed of, directing District 3 and 4. Thus the land grant committee and Tehsildar to consider the application of the petitioner within stipulated time, which was an application for regularization of unauthorized cultivation. In response to the notice paragraph, the respondents have appeared and filed compliance affidavit, filed two affidavits dated
15/3/2022
and
25/9/20.
25
9/2020.
9/23. Full stop. It was pointed out by learned government advocate Mr. Mahendra on the page of the government's in the state of affidavit, more particularly from paragraph 5, 6 and 7 of the affidavit dated 25/9/23 that the land grant committee, which is supposed to consider the application of petitioner, is not functional and is going to be reconstituted after the state assembly elections.
No, state election is over, Mala.
To be reconstituted. Full stop. Learned government advocate further makes a statement that once the committee, lands grant committee is reconstituted, within 4 weeks from the reconstitution.
6 weeks.
In case of the 6 weeks from the 6 weeks from the date of constitution, the case of the petition will be taken.
Yes.
And the necessary decision will be taken in compliance of the directions of learned. In view of the aforesaid statement, learned advocate for the complainant so and so stated that the complainant is satisfied since the decision will be taken as per the statement made. In the aforesaid view, nothing further survives for adjudication in this contempt proceedings. They are disposed of as closed.
Nice.
Verified that non-adherence to the statement by government advocate and non-compliance of the directions by the competent authorities shall expose the authorities to aggravated.
My lords, I appear for accused. My lords,
Case
Mr.
number
N.K. Ramesh has
27, I
given
appear
his
for the
NOC
complainant.
wakalat. I'll be undertaking to file the NOC wakalat, my lords. Mr. N.K. Ramesh has given NOC, my lords.
You are
You're
appealing.
filing, yes, my lords.
But it appears you made the same statement on the previous occasion also.
My lords,
You had made the same statement on the previous occasion also.
12th matter, my lords.
Ah.
But that was not an NOC wakalat, my lords. We were coming on record for first time.
Your Lordship, it has been 1 year since this contempt petition has been filed. But till today, no affidavit has been filed by the accused persons. Your Lordship, the matter.
We'll grant some time.
Your Lordship, the matter
So I don't have
pertains.
any papers. A short date may be fixed, my lords.
Yes, please.
What are the directions?
The direction is in the petition to consider the representation of the
Yes, my
complainant.
lords. I was informed this morning, my lords. I was informed about the NOC this morning, my lords. I don't have any papers, so it's short accommodation.
15th April.
15th April.
Oh, yes, my lords.
Please.
Number 28.
28, my
Manjunath V.
lords. There was a complaints report to be submitted by this, by the respondent, my lords. They haven't filed the affidavit yet. I request
The direction, my lord, was to consider the representation. We have considered the representation, allotted him an alternate site, my lord. May I place the allotment letter, my lord?
Why you are not sending these
It has been sent,
responses to the
it has been,
litigants?
allotment letter has been issued to the, dispatched to the, by post to the complainant, my lord.
When did you send that?
That allotment letter, my lord, is dated,
Allotment is done now.
it has been done, 27/2/2024 allotment has been done. As a part of the normal process, it also gets
I'll
dispatched.
verify and I'll submit with your lordships. Can be taken up next week, my lords.
We accept that one. There is no reason to doubt version coming from a panel council.
Allotment letter is
issued, allotment letters, served also. They have allotted site now. If you have any other grievance, you have to work out elsewhere.
Learned counsel for the respondent. Bangalore Development Authority produces along with the
Memo dated 28/3/24.
28/3/24 for my copy of allotment letter dated 27/2/24 depicting that site number 984. Please, madam. In the Janabharti 1 block, survey number 58, Palagera Ali village has been allotted. Yes, ma'am. To the petitioner in applicant, to the complainant, in compliance of the directions issued by learned single judge. In order dated 8th August, 2/3/2023, my lord, in compliance with the order dated 2/3/2023. Subject matter of present contempt proceedings. In the aforesaid view, the said memo and the copy of the allotment letter is taken on record. In the aforesaid view, the contempt proceeding no more survived. They are accordingly disposed.
But they are not given the possession certificate of the.
No, allotment will happen. Thereagafter, there is a protocol.
2004, my lords. It's the same
Now that will
process
happen.
Has been happening. Yeah, this is the second round of litigation. It's been going on between the.
So what more do you want?
Lords, what has happened is the possession letter is not being issued. I've been fighting from 2013.
The direction is for?
My lords,
Direction is for issuance of
direction is
possession.
for consideration.
Consideration. That has happened in your favor now.
Please, my lords.
Oblige, madam.
Number 29, Ashok B. Patil.
This proceeding, the respondent has been served.
Service has happened.
Yes, services, as per the report.
Interim order.
Yes, but there was an order of stay of the order impugned, and in violation of that, my lords, he sells the property itself.
That you have to seek the hands of the same judge.
No, my lords, what
whom
we
the
have done
matter
is,
pending.
but what we have done is, the purchaser, we have applied for impleading him. And also we have filed an application for amendment of the petition for declaration that this transaction is honest in law. And he goes scot-free after violating, he had entered caveat.
No, the learned judge will have power under section 150 because it's arise under CPC to imprison him also. That's the law. Justice Rajamannar of Madras High Court.
That power is there.
That's the law. Therefore, it's not that the learned judge is powerless. His power is coextensive with our power only.
But I follow your lordship's view, but the difficulty is the violation of the orders has become an order of the day. And because there is no coercive action against them, that's the whole thing.
Learned advocate,
Tell the
Mr.
judge.
Ashok B.
That
Patil.
please.
Mr. Patil.
Yes.
Could not dispute the factum that the order brought under contempt jurisdiction of this court in these proceedings is an interim order.
Violation of an stay order.
Single judge in the pending proceedings of the writ petition. Full stop. Since it is an interim order, the controversy is at large before learn a single judge on merits. This court is not inclined to enter in the contempt application as against the interim order. The contempt jurisdiction is not required to be exercised. Paragraph. It will be open for the complainant to approach the spot where the proceedings of merit petition are pending to work out his rights and remedies in accordance with law.
But another
On the
practical
state-
difficulty what we are
on the
facing
state
before
ground
the,
and- On the state ground alone, the contempt is petition not entertained and same is dismissed. This
but
court-
before
this court-
before the GM roster bench, posting of the even interlocutor application has become a task. Every day, more than 100 matters are listed, date given matters, so therefore, even though our memos are moved before the honorable judge.
It's a matter of administrative
No,
difficulty.
I'm only bringing,
That is not- that is- that is
I'm
no ground
relegated,
to entertain.
but now I'm relegated to before the learned single judge, but this practical difficulty, my lords, we are facing day in and day out.
We'll try to solve that.
Grateful.
December 32, December 30, with Anandishwara DR.
For accused number 1, my lord, the learned single judge are directed to consider their representation and pass appropriate order. That has been done, my lord. Khata has been restored in the name of the.
You complied with the.
Please.
No, Your Lordship, may I kindly say wrongly they have mentioned. Please, my property number has been wrongly mentioned, my lord. Your Lordship, may I kindly say my property number is number 87/1. Whole number is 145 bar A, my lord. In the endorsement, my lord, they have mentioned in the whole number is 145/19.
What
This
was
is
the direction, brother?
direction to consider the representation and pass. But in the endorsement, my lord, they have mentioned a property number wrongly, my lord. That's what I mean. That is the main. Intentionally, there were 3 times, my lord, their property number has been wrongly mentioned, my lord. That is my property number is 87/1. Old number is 145 bar A.
145 bar A.
Please, man. That is the
But
original.
145 by 19 they have written.
Please, man.
That should be A.
Yes,
Please,
that I will, I will
In the
instruct the concerned
body of the letter
state
also it has mentioned, my lord.
to have it corrected, my lord. I will instruct the concerned officer.
They have restored the khata now.
Yes, my lord. It has been restored in the name of the
But again,
complainant.
that again is with defect only.
New number is correct, my lord. Only old number is not.
That will
there.
generate lot of.
19 has been added, my lord, instead of A.
Yes, I will instruct the concerned officer.
145 A is the old
rectify
number.
that.
He's saying that you
Please,
will
sir,
rectify it as 145 capital A.
Please.
Please, my.
We can only.
It appears to be a mistake. Error. Transcripts. Right.
No, original order itself is. They should have said 145 capital A instead of 145 19. it has come. That they're saying they will rectify that.
Will rectify it.
Yes.
Please, my lord. Please.
In this contempt application, the grievance was made that the direction issued by a single judge in order dated 24/8/23 to consider the representation of the petitioner dated 30/11/22 was not complied with. The representation was with regard to the change of khata. Today, when the paragraph proceedings came up for consideration from a learned advocate of the respondent, abused time quoted. 28/3/24, along with which also produced is the endorsement dated 25 and 24, in which it is stated that the change of khata in respect of the property concerned will be kept. Full stop. Any of the said endorsement indicating that the change of khata has been acted upon in favor of the petitioner. From the present contempt proceedings no more survives. They are closed. Paragraph. However, at this stage, the learned advocate, Mr. So and so, the complainant stated that then the endorsement dated 25/1/24 old, as well as in the original order, 25/124, comma, old number 145, inverted comma, old number 125, inverted comma, is wrongly indicated, which ought to have been old number 145, public A. A or 1?
A, please.
A. Full stop. Learned advocate for the respondent accepts.
Please.
That there is an error in error of transcription. He further
In the very original order.
error in the original, in issuing the order itself, as the wrong old number is mentioned. He assured, he made a statement that the competent authority shall rectify the number from 145 to 145.
Bar A.
Oblique A.
145 bar 1. E. To 140.
145, 19 to
19.
19 to upper per 19. 145 capital A. And the correction and the corrected order shall be issued within 1
Within
week.
2 weeks.
1 week.
1 week, please.
1 week. 1 week.
Please.
Before said direction, based on statement. Contempt procedure.
Same.
Why you do not send these endorsements?
Yeah, it has
to
been
the
sent, my lord, sent by register post.
Number of cases, that's only to, it gives us an impression.
Please.
Which we cannot say because we are sitting on this side. Don't tell your officers not to do that mischief.
Please.
Warn them. Otherwise, in some matter, we'll haul you up for contempt.
Please, I
This
will
is only
instruct
to
them.
see that the citizen comes to their table. And obviously for, will not say anything else. You should send endorsement to the citizen. Why citizen should come and stand before you? You
No,
are
it
not
has
the
been-
magistrates.
In this matter, my lord, it has been sent by register post in February itself, my lord.
Otherwise, they would not, for most of the cases coming here, only because you do not send the response, they will not send it deliberately. Because they want the citizen to come salute them and do something else.
I will instruct them, my lord.
But in some
Please.
matter,
Please.
we are just waiting for some matter. See what we will do. Really, we are very, very angry on that.
Please.
Ajay. Number 31, Mr. Bharat Kumar V.
For the complaint. The respondent, Lord, may I seek some time, Lord, this is the first time it's come. Some time for.
Not ready. Not complied.
This is the first time it has come. Lord.
First time
I'll-
it has.
Yes. I request for
Then
some.
we'll
time.
fix a time within that you do. If you do not do, aggravated contempt. There is an order, you have not put it in appeal.
Yes.
Consideration has to take place.
Consideration has to take. place.
Yes.
Lordship may have it after this present elections, Lord, but then I'll come before your lordships. Because otherwise.
Just on 19th, my lords,
2nd
19th of April.
2nd April.
Lordship may have 19th,
Further,
please,
15th.
please, great.
Hearing on applications, introductory applications, number 32. Hardik Palle.
Please, my lords. Upon a joint submission made by the petitioner
Application may
on
be
the
allowed. May be allowed.
Allowed. In terms of which judgment?
In terms of the judgment passed on the very same day, on 14 to 24 one, there are two petitions. In the affidavit, they have called out.
because I have filed an IA stating that I am not issued with the MDRO, that is mineral dispatch permits. That's only a modification I sought, my lords, even if.
So substantially similar order.
Yes, my lords. But the only thing is integrated lease mining system is to be adopted. And we approached the deputy commissioner also. The officer is declined to entertain our request. That's why this IA has been filed. And if learned government advocate submits. Even with-
Identical matter, substantially similar.
Same.
Therefore, similar relief has to be granted.
Yes, but only ILMS is to be inserted, my lords.
In terms of this, that will take care of your para 8 will take care of your submission. 8 of the judgment.
Yes, my lords, but because it is found a place in the body of the order, but not in the operative portion of the order. That is their grievance, my lords. This petition has already been disposed in terms of the order, but the opening sentence of the order is in terms of the integrated lease management system and in terms of the order of even dated.
What is spread in this writ petition is to set aside the temporary suspension order dated 25/1/24 passed by Respondent 2 dash the Deputy Commissioner. Also, whereby the petitioner is called upon to stop and suspend the operations in the stone crusher unit. Is further paid to direct set aside the power order of disconnecting power dated this order dated 31/1/24 disconnecting the power unit of the petition by Respondent 6, which is the order passed by Respondent 6. It is the case of the petitioner inter alia that the license for his live stone crusher unit is valid till 31/3/37. Yet the aforesaid orders are passed. So in course of at the time of the hearing of the writ petition, learned advocate, the respective parties appearing through the parties appearing through respective learned advocates, Mr. So-and-so for the petitioner, and learned government advocate, Mr. Mahendra, respondent, were added up that the similar issue was addressed by the court in writ petition number 4319
between the same parties.
Decided on 14th February 24, which were the proceedings between the same parties.
Yes.
Full stop.
Matter has already been disposed, my lords.
Not between the same parties. That is different. VPS, as VPS rocks.
Two different parties.
That's not between the same parties.
So this is for correction of the judgment. Correction of judgment is
who has
the petition.
For what?
To
Seeking
continue with the stone
clarification
crusher
that ILMS is appearing in the body of the order, but not in the operative portion of the order.
Yeah, what?
Stating that I must also be issued with MDRO or ILMS system.
The said judgment was, the said order dated 14 February 24 was again based on another decision of this court in Messrs. VPS Rocks Company versus State of Karnataka and others, which was writ petition number 4088 of 24 decided 4088 of 24. In light of the above, the relief on the same lines deserves to be granted to the petitioner. Accordingly, following order is passed.
There is some small say school of matter that it should cover for issue of mineral dispatch lease order through integrated lease management system. This sentence to be added somewhere. First paragraph. But there is a judgment of division bench judgment ILR 1994, AR 1994 Karnataka. Division bench said, while we need not see just the order portion, operative portion, but entire judgment should be read and understood with common sense.
Even my junior colleague went and approached the deputy commissioner. She is reluctant to give an audience. Still we persuaded No, it is not found a place in your body of operative portion order. We are not going. You can do whatever you would like to do. Very,
Begins with that only. He wants this to be here.
But this is the same order.
Same order.
Same order.
So why do you file second petition?
No, rectification.
This is
Application is
No,
filed.
this is the same order.
Order two separate orders were launched.
The impugn order dated 25/1/24, passed by respond to Deputy Commissioner, is hereby set aside. 2, this will not satisfy. So the petitioner is at liberty to file fresh reply to the notice issued to him, which was the basis of the impugn order, which is now set aside as above. 3.
His application for grant of permits.
The petitioner shall be heard after granting an opportunity.
Yeah?
The petitioner shall be
Only this
heard
sentence.
after granting opportunity.
Consider his request for issuance of mineral dispatch. Same sentence.
3. The petitioner shall be heard after granting an opportunity of petitioner to him, and a joint survey shall be conducted in presence of the petitioner. Full stop. Next, the respondent authorities thereafter pass appropriate orders in accordance with law. Next.
For issuance of mineral dispatch release order.
Issuance of mineral dispatch release order, MDR, bracket or through integrated lease management
That's all.
shall be issued. The mineral dispatch release order, MDR through integrated lease management system, ILMS, to meet the shall be issued by the
Consider.
provided the decision is in favor of the petitioner. The petition is disposed of in terms of the aforesaid observations and direction.
Application disposed.
All applications are disposed.
Support your affidavit for the application for clarification, which Chief has made. Yes.
Application support,
application disposed.
the supporting application is also disposed of since the direction is incorporated.
Please, ma'am.
33, Mr. M.B. Chandrachud.
Appeal was presented before the court on 4/8/2022. Matter was listed before the register for non-compliance of office restriction. It was dismissed for non-appearance of the appellant before the register. On 17/10/2022, I filed an application. I complied all the objections.
Register judicial order. Protocol for non-prosecution. Compliance.
I have complied the office objection.
Format is office objection. Standard form. To be allowed. Restoration. Yes, sir.
Within office of this, we complied with
Yes,
it?
complied also.
Already.
Yes.
Already complied.
I already complied.
Very good.
Postpone.
Submission. Number 43, my lord. Complied, not the dispute.
Accused has completed the single judge orders. Please.
So dispute of
43.
It's compliance. Order is compliant.
Which
43.
43.
Question to pass order, pass.
Learned advocates for the respective party stated that the order under contempt is complied with. In that view, nothing survives in the contempt proceeding. They are disposed of.
Please.
Closed.
Please.
And for appellant, your lordship, I have filed the memo for withdrawal of the appeal.
Withdrawal,
Please, your lordship.
69.
Please, your lordship.
Learned Advocate Miss Anu Bharadwaj.
Medini Rao. Medini Rao.
Invites attention of the court to the memo dated 28/3/24 for withdrawal of the present writ appeal. The memo reads as under court the memo. In view of the memo, the appeal is permitted to be withdrawn. Disposed of accordingly. Stay application will not survive in your disposal of the main appeal.
I appeal for the respondent. Lord, here yesterday evening, Lord, they have paid the transfer charges for the BDA. Lord, then they said they will be coming for registration on Wednesday or Thursday.
Wednesday.
Wednesday or Thursday. They may come for registration.
We had heard this from the other. Told them that it will do it. No, it says on Wednesday.
They would come for, they would come for registration.
Perhaps you don't have communication from your client, the PS. On Wednesday, you will be executing the sale deed.
The day they come, we'll execute the sale deed. So they wanted to see some auspicious.
The day on which they call me, I'll go.
My instructions are that they wanted to see some auspicious dates.
He says he will execute the sale deed.
Learned government.
Within 1 week, you execute the sale
You are
deed.
saying, what is your good name?
Murugesh.
Learned Advocate Mr. So-and-so, for the respondent, makes a statement that pursuant to the observations and directions of learned single judge in order dated 7/11/22 in writ petition number 17297/22, the respondent authority will execute the absolute sale deed in favor of the petitioner in respect of the immovable property bearing site number 21, now new BBMP municipal khata number 56 and 57.
Within 1 week.
Situated at Viviani Road, Richmond Town, Bengaluru, within
1 week.
1 week from today.
Yes.
Subject to compliance, usual compliances.
Yes.
Subject to usual compliance of the formalities by the parties. The first statement satisfies the complainant appearing through learned advocate, Mr. So-and-so. Contempt proceedings are closed and disposed.
Okay, next week, madam.
No, disposed. If they do not do, you come here.
That is what
Plazas.
In the event the statement is not abided by, it will expose the respondent authority.
Aggravated contempt.
Unless the matter is pending, there will not be any pressure on them.
No, they will have aggravated contempt. My lord has said, if they do not abide by their undertaking now, it would expose them to the aggravated contempt.
It is called next week, my lord, they will do it.
May not be.
They will.
I leave it.
Number 34, Kaligutla Nitya.
No, my lords. Petition is filed seeking a writ of mandamus to prevent the respondents from changing the nature of the civic amenity site, which is designated as a playground. My lords may see Annexure D, which is the layout plan at page 53. At page 55, my lords will see of the petition.
From playground to other, are you changing the nature of the property?
Yet to receive instructions, Lord, they had served me a copies. Some few days back, I've sent it to the BDA for instruction, yet to
From
receive
5th March
instruction.
minutes.
5th March, they had served me.
Who changes it?
These plant saplings and plants and trees are being
No, no,
planted.
who is the authority who would change?
It will be the BBMP or the BDA. Once a civic community site is designated as a park or playground, it is not transferred to any independent private entity. It remains with the corporation.
So how, when it is earmarked as playground?
Please, my lords, may see annexure D. That's the layout plan at page 55. My lords may see CA site number 3. The left-hand portion says children's park and playground, and the right-hand portion says proposed for school. In fact, the BBMP, my lords, having admitted that this is a playground, has put up a board on the site that is at page 68, annexure H.
They are converting into what?
Into a park, my lord, by planting trees. Now, what is happening is a portion of the site is already a park developed by the BBMP.
But the area belongs to you?
My lords, me see page number 55, the right side portion which is proposed for school, that has been allotted to me.
You are running school.
I'm running the school over there. The playground is used both by the children of the layout and also by my students.
So is there anything to show that this playground area was given to you?
No, I'm not claiming exclusive use of the playground area. I'm not claiming any exclusive use of the playground area. I'm only seeking that the nature of that civic community site not be changed from a playground.
But you cannot.
I'm not claiming exclusive use, please. I'm not changing the nature either.
You are using as playground.
Please, I'm also, my students are also using it as a
So under
as a
what
playground.
authority? Any permission?
Please, my lords, may see the allotment to me at annexure G. It is a public playground and my school is situated next to that public playground.
You are not supposed to, Apex Code says,
Please,
if
my
you are personally interested in the cause, you cannot maintain a writ petition.
Please, my lords, I filed this petition as a writ petition before the learned single judge. My lords may see the order dated 27/10/2023. The learned single judge was of the opinion that the relief sought by me were in the nature of public interest and has directed me to file it as a public interest litigation.
Where is that?
The orders 27/10.
No, not that.
Please.
That the order which my lord was
Allotting
asking
to-
you, na?
Please, my lords. That is at annexure G, my lords, at page 62. The translation is at page 65. This is the resolution of the BDA, which is the respondent
These
number 2.
Translations they have not given, I believe. Yes.
Resolution number 9 on page 66, my lords.
You do not have independent playground.
I do not have an independent.
Exactly.
Under the
That is the
rules,
point, my lord.
that
That is
Supreme
the
Court
point.
say, she's supposed to have. In the guise of this, they cannot use that.
Under the guise of this writ petition, they want to use exclusively this.
I'm
petition.
not claiming exclusive
My lord,
use.
no, no.
That is not, I'm willing to give an undertaking that I'm not preventing any children of the layout from playing in this playground.
Petition is not maintainable. The Supreme Court said in 3-4 judgments, almost identical factors. They cannot maintain the PR. If the learned judge said like that, they should have brought it in appeal before us. It's the wrong decision. We cannot treat it as a.
Please, my lords, may give me liberty to go back before the learned single judge, my lord. Because I had filed it before the learned single judge as a writ petition and was directed to be converted. That order, my lords, is on 27/10/2023.
Where is that order with learner single says that this is?
Please, my lords, it should be the order dated 27/10/2023.
Page? 70.
Page 3 of, my lords, it's part of my lord's order sheet. It's the same writ petition itself. I'll just pass.
Your obligation to provide a playground for the children
Please, my lords.
is not discharged
Please, my lords.
by showing the playground in the park.
Please, my lords. In fact, the Supreme Court recently, Justice Nagaratna sitting at the Supreme Court had issued a judgment where she says that the school does not have a playground and there's a designated playground next to the school. That should not be changed. That use of the playground next to the school should not be changed. Lords, I produced that judgment.
Anyway,
in
that's
my-
not a case. It's an
Please.
individual case, whichever you want to do.
Please, my lords, may
Otherwise,
please give me liberty to go back to the single judge in that case.
While we have been put to notice by learned advocate for the petitioner on the order dated 27/10/23 of learned single judge, pursuant to which the present petition has been brought before us as public interest litigation, considering the subject matter of grievance where the petitioner trust wants the court the direction to the authorities for not converting the use of the land area adjacent to the school run by the petitioner to any other purpose on the ground that the petitioner school has been utilizing the said area as playground.
Please.
The school children, the code finds that it amounts to the petitioner having a personal interest in the subject matter. Full stop. Therefore, when the grievance is of personal nature, it could be better agitated in proceedings other than public interest. Full stop. Therefore, on the said ground alone, without going into the merits of the controversy, the liberty is reserved for the petitioner to file the appropriate proceedings.
My lords, may
for
list this matter
ventilation of
before.
the
My lords, may list this matter again before the single judge, please. Apologies.
But Ordinance judge said everybody should go back to the next.
Liberty reserved to petitioner to approach learner single judge with this very petition.
Petition to be transmitted.
Notwithstanding the aforementioned order dated 27/10/20. Also, registry shall
And back the papers too. No, absolutely.
registry shall permit the conversion according.
Obliged.
Number 35, Mr. Sandesh Kumar M.
Here for the Petitioners Council. Slightly peculiar problem, my lord, for us. We were, my lord, granted 20 guntas of quarry land, 4 of us. We are, my lord, quarry workers to whom, my lord, these grants were made in 2010. And, my lord, this, every year there's been an annual audit in terms of Rule 40 of the mineral concession rules. And there has been no issue raised, my lord, insofar as the identification of our area is concerned. Subsequently, in 23, the government, my lord, calls for
Lease it to other persons.
they want to lease, and that overlaps with our area. Of course, in the objection statement, my lord, my learned friend says it does not overlap. All I am requesting, I am not in possession of more than 20 guntas. I'm only requesting that please identify my 20 guntas. And thereafter, wherever else it is to be given, it can be given. But in the 20 guntas where I have, it is not done in the chain link system. And it says so in the mining lease as well. Now they do use a GPS coordinate, and on the basis of which not identification is made. That's the entirety of the issue. So, though of course the challenges to the new mining lease, my issue is that my 20 guntas or 4 of us.
But the entire extent of lease granted to you measures how much?
2 acres for 4 of us, 20 guntas each. There are 4 petitioners. Each of them will not have a separate mining lease. Each is for half an acre.
In each of the cases, boundary is fixed.
It's fixed. Boundary is fixed. And my lord, it is there in the mining lease deed itself on the basis of a chain link method, which is specified there itself. May I request my lord to kindly come to page 60, one of the mining leases.
So 20 guntas of land has been made subject matter of the sale deed executed in 2006.
No, mining lease. Mining lease. It's a quarry.
Instead of saying it's a government. Therefore, while granting the
They are all quarry workers, ma'am.
Your land is treated as mining land.
Yes, ma'am.
And the sale deed is executed.
Lease deed.
No, lease deed.
Sorry, lease deed is executed in favor of number 6.
Yes, ma'am.
Which includes your land.
20
Yes.
20 guntas.
A portion of it, my lord, is overlapping with our land.
Correct. Same thing.
Yes.
So all I'm requesting is that.
That can be addressed by his joint survey.
Yes, can be addressed by a joint survey.
When similar matter arose under the Forest Act 63 A or B, something like that, this court took the view, in such a case, the survey of the land has to be undertaken with the mining department and revenue department with the participation of parties. If that is done, everything will be over.
Yes, that has been done, but we have produced annexure R9.
But you did not involve
That is not required for this reason. Lord, in the lease deed itself, geo coordinates are provided. Mentioned. Geo coordinates are mentioned on an earlier occasion for violation of the boundary pillars. Yes.
In his lease also it is mentioned.
Yes. You'll ask me kindly take up my statement of objections, wherein it is clearly stated. Para 3, Lord, I have tabulated.
No, we have a mining history of more than 100 years in the country.
Yes.
Where such things happen, how, what the protocol provides for resolution, how these are resolved.
Yes. Lord, if their contention is, Lord, this is overlapping with the present
6 respondents lease.
Lord, one of the Lord, brother of the petitioner participated in the action of the very same lease area on the last occasion. That was annulled. Subsequently, this portion was 2 acres was auctioned in the year 2023. They have not questioned that auction. No. Now they are questioning the execution of lease deed in favor of R6. The prayer made in this petition is
to set aside to
that
extent.
Their extent. Lord, it is not their case throughout. Lord, from we have executed the deemed extension lease deed in the year 2016. 16 itself. They are complaining after lapse of so many years.
I'm not
Lord, in the year 2024. After this action notification has been put forth and Lord, lease deed has been executed.
What is the extent of land which they are holding now under the leases in question?
20 guntas each.
No reduction at all.
No reduction.
It is 20 guntas.
20 guntas.
On what basis you are saying that it is less than 20 guntas?
No, I'm not saying it's less than 20 guntas. I'm saying minus 20 guntas. I don't want more. I don't want less.
Correct.
What is happening is now the new allocation which they've made actually, my lord, intersects with our boundary, where we are carrying out quarry operations. That's all.
But since last 2016, you have done, you were very, very happy with everything.
I'm very happy, my lord. I'm not, my lord, which is why I respectfully started off my submission saying it is not the question of challenging the auction that they've carried out. That is not my intention. I don't want to do it. But when they came to mark their boundaries, it intersected with our area. So I made a representation at annexure N. Please see page 536.
Correct. But all these years, you were working your lease accordingly.
Yes, I only want that. I only want that. I don't want anything more.
Even otherwise, if there is dispute as to the numbers and the boundaries, the boundary will prevail. Boundary is mentioned here.
Yes, my lord.
That accords with the.
No, as a matter of fact, please see annexure M, which is the notification issued by the government with respect to scenarios of this kind, because these are hilly regions. And my lord, the identification of the boundaries was made with the chain link method. It's there in the mining lease itself. They've provided for an eventuality as to how it has to be determined. I'm not, of course, the translated copies. May I just pass it on? I'm so sorry. I think only a portion of it was there.
Page number?
Lord, annexure M is at page number 496. I'm sorry, 496. That's in Kannada, my lord. I'm just giving you lordship's the translation.
Your case is they were holding this 20 guntas in excess of what is allotted to them. No, it was left apart.
Not apart.
It was kept apart.
The sketch which I have produced, it makes it clear. You'll ask me kindly produce annexure 9 sketch. Not 813 is the lease.
Which page?
page number 7 of my statement of. Oh, sorry, page 30 of.
30, the last
30,
document.
last one. Independently.
Yes, still.
Lord, in this case, Lord, the lordship would see 813. 813 is the now auctioned lease.
813.
813.
Where it comes?
In the Lord,
there's block 2, next to
38,
block 2.
number 38 is mentioned here. Lord.
So this 813 is what?
813 is the lease executed in favor of respondent number 6. That was auctioned now.
And their leases fit into which numbers?
Their leases, Lord, in case of Gurumurthy and all that, we have mentioned.
All other?
All other, 680, 673, Lord, petitioners are.
All of this are lease.
All green belong to petitioners?
Yes.
4 blocks of 20 guntas each.
Yes, but this is a separate land only.
That's the difficulty. Here it's showing as a separate land, but when they measure it there, it's intersecting with our land.
And last may kindly come to page number 2, para 3.
Which one is in the sketch?
Yes, sir. Lord, here we have tabulated in respect of all the leases, Lord. In respect of petitioner number 1, in page number 3, GPS coordinates are mentioned.
What is the accuracy level of GPS surveys?
Surveys, it is accurate, Lord, plus or minus 3 meters.
No margin of error. Error margin is how much?
Plus or minus.
Ask them. No, but you have to bring such people who will answer court's question.
Please.
Otherwise, how are you going to decide?
Lord, in this case, in page number 3, your Lordship may kindly see, in all the cases of petitioners, Lord, they have violated the boundary norms and we have imposed fine.
They have
and
paid.
they have accepted
Paid
and
also.
paid.
Boundary.
Not only, Lord, in respect of all they are encroaching upon the other area. They are conducting mining, quarrying operation.
No, there's no such
Now,
allegation. No, there's no such allegation of violating any one area.
I am
Till
stating
today,
on affidavit.
all that was said, my lord, was there were no boundary stones. That is all. Not that they encroached into some other area.
No, you have paid the penalties also.
The penalty was paid for not keeping the boundary stones in place. That's
Where
all.
are the penalty orders?
500 rupees.
Penalty orders we have not produced.
Then if you produce them, we can hold it to the petitioners. Otherwise, you will say something on affidavit, he will deny it again on a counter affidavit. Then we cannot decide all that.
It is an admitted fact. No? It cannot
What
be.
is admitted?
Under 6.3, we have imposed fine, they have paid. Let them deny it, Lord. On affidavit, I am saying.
No, that's all right. But that can be shown by the orders themselves.
Yes,
Produce those orders and.
Lord, even in this case, Lord, you'll ask me kindly peruse the prayer. Prayer is to watch the lease executed in favor of R6. Now a new case is sought to be made out.
They're seeking more. That does not mean they are not entitled to less. If otherwise they are entitled to. On the ground that they have claimed more than what they are entitled to. Can we say that you are not?
No, if their case is not, if their case is that there is a mistake in the boundary fixation of boundary or something like that, then they have to make a application under Rule 17.3.
73.
17 subclass 3.
There is a procedure for.
There is a procedure
for physical survey.
For physical survey.
For survey demarcation of the area grant.
Then you make that application and they will consider that. You cannot challenge the grant.
Which is why I state to him, Lord, first thing I said was I'm not challenging. Nor we can grant this prayer in wholesale.
Correct. You can make an application.
Yes.
Even if we could have granted, we could have granted in part or some by holding it. But now this rule is available.
But the rule says,
Then appeal will be there.
yes,
Then
due to a
you-
technical error, if there is a,
Can
no,
change.
of course, no, I want to make one thing clear, my lord. My learned friend, of course, very assiduously, my lord, says that we are violating various rules. But the rule which is violated, my lord, is in respect of boundary stones not being found on the date of conducting audit, nothing more.
No, we have some reason to doubt your version of your client.
My lord.
Because he is the person who has breached the condition and paid the penalty.
Yes, my lord,
And
which is the
therefore-
boundary stone penalty. You did not keep boundary stones as the allegation. Boundary stones are subsequently kept, and thereafter, my lord, nothing else.
17 provides for remedy. 17 provides for remedy. You
17
make an
17.3,
application.
if any variation found in quarry lease
Yes,
or license.
17.3 of course provides for that. 17.3,
Yes.
and my lord, there are guidelines issued which is annexure M.
No,
If it is done on that basis, I have no difficulty. my lord.
No, no, you have to.
Make an
file-
application for this. There is a payment of 2,000 rupees per acre.
That
You make that
4,000 rupees totally for us.
So you make that application, so they will consider it in a time bound way.
Yes.
Yes, ma'am. That can be done.
They agree. They should make the application and they should consider the application in a time bound way.
Assisted by learned advocate Mrs. So-and-so for the petitioner. And learned government advocate Mr. Mahendra for the respondent authorities. Paragraph required under Article 226 of the Constitution. In this petition, what is prayed by the petitioner is to set aside the lease license deed executed by the competent authority in favor of the lease license deed dated 25th September 23, executed by the competent authority in favor of respondent 6. It is also a prayer seeking direction against the respondent number 1 to 5 to review the quarrying lease license, quarrying lease license deed given in favor of the state respondent. 6. The premise of facts paragraph on which the aforesaid prayers are based are inter alia that the petitioners have been carrying on the stone mining operations from 8/4/2010. All the 4 petitioners have been carrying out stone mining operations from 8/4/2010. In survey number 38, in land survey number 38 of Melina Kuruwali village, Tirthalali Taluk, Shivamoga district, and that they are given license for 20 years from 8 to 2010 to undertake the mining work. It is their case paragraph that pursuant to notification dated 23/11/21 by the Director, Department of Mines and Geology, whereby certain areas were notified as land available for grant of quarrying lease. From a lease cum license deed came to be executed on 4/10/23 in favor of respondent 6 herein. It is their grievance that while granting the lease to the said respondent, the area given to the said respondent has overlapped the quarry land given to the petitioners. It is therefore they have right to set aside the lease deed executed in favor of the said respondent. Having considered the basic dispute and having heard both the sides, the court could immediately notice that Rule 17 of the Karnataka Minor Mineral Concession Rules 1994 permits survey and demarcation of the area granted for co-release. The said rule reads as under in Court Rule 17. Four may not be. Four dot 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 1, 2, 3. Provided that dot dot dot. Rest of the to be quoted. Under the aforesaid rule, it will be permissible for the petitioner to approach the competent authority for survey and demarcation of the exit area of petitioners of their co-release by an S or in S full stop. Since the dispute here is essentially about the physical boundaries of the lease area granted to respondent 6 vis-a-vis the lease enjoyed by the vis-a-vis the area of lease enjoyed by the petitioners, the survey and demarcation under the aforesaid rule would be a proper recourse required to be taken by the petitioner. Paragraph. The prayers made in the petition cannot be granted. 4. It involves the fact-finding exercise, which can be undertaken only by way of survey and demarcation to be gone into under the aforesaid rules. Leaving it open for the petitioner to apply under the aforesaid rule by paying necessary fees. This petition is disposed of.
Number 36. Petitioner.
He says it's covered by the judgment.
Not covered. We'll consider his
Like
application.
Dodana's case.
Ordinance case is different. Here, in view of the 17/3/2023 notification, he is seeking extension of this. All that the prayer is to consider his application.
You consider according to law and send the endorsement.
That's it. But we need some time because this new amendment came into force on 17/3/2023. Thereafter, we have received around 16,000 applications. 16,000 applications. We require some time to consider. I'm sorry, 1,600.
Therefore, it cannot be 16,000 at all. We don't have so much.
1,600. I stand corrected.
6/4/2023, I filed the application. 1 year, even application is not even sent to the Assistant Commissioner, Deputy Conservator, seeking their opinion.
Our learned advocate, Mr. L. Chida Sandaya for the petitioner and learned government advocate Mr. Mahindra for the respondent state of Karnataka. Respondent state and its authority. The only prayer made in this writ petition, filed under Article 226 of the Constitution, is to direct respondent number 2. That's the Director, Department of Mines and Geology, Bangalore, to consider the application dated 10/4/23 of the petitioner for grant of co-release by obtaining the opinion of the Assistant Commissioner from a Deputy Conservator of Forest and further obtaining a joint inspection report. The co-release is applied under the said application for removing the building stone paragraph. It was rightly submitted paragraph by learned government leader that the state government, the authority is bound to consider in accordance with law any application which may be made by the city, made by a part, made by any person. And that Article 350 of the Constitution mandates to take a decision expeditiously. Full stop. In the above view, this writ petition is disposed of by directing the competent authority of respondents to consider the application of petitioner and take an appropriate decision in accordance with law, preferably within a period of 8 weeks.
6 months, my lord.
6
months, because the joint inspection has to be conducted. There are so many.
6 months. Full stop. The court does not express any opinion on the merits of the application of the petitioner. Please, the present petition is disposed of in terms of the above observed.
Number 37. From Muni Rajgopal.
May please, my lords. Lords, considering the safety of KR Sagar Dam, my lords, the Honorable Court, considering the safety of KR Sagar Dam, my lords, this Honorable Court, by its order dated 8/1/2024, had issued certain directions in order to see to it that the mining activities, and allied activities are not carried out within a radius of 20 kilometers, my lords. Now, the present petitioner's stone crushing unit is outside the 20 kilometers radius, my lords, but by the impugned order, my lords, they had restricted him. It is under these circumstances we came before this Honorable Court, my lords, and we were able
potential impact of plastic. Which is that order where myself
my
and
lords, page 147, my lords, annexure L.
Chidanandaya had argued that.
Yes.
My lords, it's at page 146, annexure L. My lords, the order would commence at page 147. My lords, considered the mining activities happening around that area, and mainly, my lords, the blasting and the seismic activity is happening, which is affecting the dam, my lords. That is what my lords was pleased to consider. But however, my lords in the direction said mining activities and allied activities, my lords. So my lords, I take it that even allied activities may include stone crushing. Those stone crushing, there's no blasting, nothing of that kind, my lord. Stones are put, sand is taken out.
Where
But
from the stones come?
my lord, stones come from quarries. Quarries can be way outside, my lords. From my, so far as my place is concerned, I get it from a quarry which is 21 kilometers away from the dam, which has not been stopped from its activity. So I am getting my building stone from a quarry, my lords, which is carrying out the activity. I put the stone into the unit and I get sand. And my lords, the distance, just to make sure, my lords, that the distance is beyond 20 kilometers, I have produced the documents even under the Right to Information Act, my lords. My lords,
Where from they bring the stones?
The very adjacent to the crusher, they have a quarry lease, is my instruction.
Within the radius of 20 kilometers?
No, beyond the radius of 20 kilometer, but whereas this crusher is situated within the.
Crusher may be beside the dam itself.
Not within the periphery of 20 kilometers.
Very well, but crusher you need.
No, as per
Does not
this
fit
order.
into allied activities.
Yes, Lord.
Blast activities, which Mr. Sondi the other day, he assisted us in that matter. Chidanandaya and Sondi. The object was to ensure that, because we have been fighting water disputes, almost like wars between the states. If something happens to the dam itself, that will be disastrous.
A similar issue came up.
Fortunately, no state has its own army under our constitution. We are saved. But the allied activities, Mr. Sondi, perhaps you assisted us.
my lords, could I just point out, my lords, the full bench of the Allahabad High Court took a decision, Madhya Pradesh, I'm sorry, my lords, they took a decision that the crushing unit doesn't come under mining activity at all, my lords. Could I just point it out?
That's the definition of mining is something else.
My lords, if just one portion, my lords, sees, my lords, why they say crushing unit stands on a different footing, could I? My lords,
share a copy of that judgment with
I
Mr.
just,
Sondi.
just one portion, my lords.
Also get a set of the papers from my friend. Perhaps your lordships would club this with the pending.
My lords.
Yeah.
It's pending, it is.
Yes.
No, we have used the
allied activities.
Allied activities.
Lords, that's where my submission to your lordships in the previous occasion was, let that expert committee take a decision.
The committee is also constituted.
Committee is constituted. And my lords were pleased to direct certain impleading applicants in that case to approach the committee. Ultimately, my lords, whatever the terminology, the committee must assess if there is a threat.
Whether
If
it
not,
is by.
by all means, they can go ahead.
We are not interpreting any definition given by the statute. We have used it with our,
yes,
with my poor language perhaps, we have used it that way. The object is to ensure Nothing happens to the dam.
My lords,
Nothing beyond that.
very specifically, my lords felt 20 kilometers radius. Let's take it 20 kilometers radius, no mining, no crushing activities. I am outside 20 kilometers as acknowledged by the Mines and Geology Department itself. My lords may kindly notice, my lords, page 153. Page 153, the distance between the dam.
No.
I will not stand on the same footing as others, my lords.
That requires, how to manage, that's the problem.
My lord,
Problem is,
yes.
The same question was asked to Lord Macaulay. Why are you prohibiting manufacturing of counterfeit, parts of counterfeit manufacturing machines? He said the answer was given by him. He's a famous biographer, Emil Ludwig. He writes that. He said, everything that would facilitate these things should be prohibited. That way.
Yes.
It is not that you can, it is like saying, we will manufacture only counterfeit producing machines, but we will not use it. No, Macaulay did not agree when he coined those provisions in IPC. That way.
My lords, could I just say, my lords, leaving apart that argument altogether, my lords, if I'm outside 20 kilometers, then my lords, the order which has been passed has to go. My lords, my endeavor is to show that I'm outside 20 kilometers as accepted by the department themselves. Even at an undisputed point of time, they have pointed out, I am outside 20 kilometers. I have produced those documents, my lords. My lords, page 153 for a minute, my lords. Page.
No, not question is where your crushing unit functions. That is not the question.
It's outside 20
Where from you bring the material for
My
crushment?
lords, even that we have pointed out, the material we get for crushing is outside this 20 kilometers as accepted by them. That is not prevented. The quarry is not.
Lord, we have written a letter to Kaveri Niravari Nigama to measure the distance between the crusher as well as the dam. Lord, I have produced the document. Lord. It is within 20 kilometers from the.
No, crushing unit may be. Crushing unit as such does not.
They are asking for pressure unit only.
Just give me 2 minutes, my lords, on the documents I have produced. My lords, before.
Since we have already worked on this, I assume at least little we know that way. The question is not where the crushing unit is installed. It may be within 1-2 kilometers from the periphery of the dam itself. Whether that activity would endanger the dam is the question. Obviously, the first question, answer, immediate blush of the answer would be that it will not, because crushing takes place, like crushing of sugar cane for juice, little more sound. Question is for whether that would facilitate an activity which eventually result into potential danger to the dam. That is the question.
That is why, my lords, I submitted perhaps the expert committee would be best placed to make that assessment.
Now expert committee is there.
Yes, under the statute.
Those activities may result into within the piece of this, and who will be going to supervise everything? 24 hours it is possible to supervise this.
So all activities which are potent, imposing danger, are related.
We'll have the report of the expert committee, then we can decide. We lack expertise.
My lords, I understand, my lords. If it was to be within that, I do understand expert committee would be right, my lords. My endeavor, my lords, please notice my endeavor is that it is not within 20 kilometers as accepted by the department, which they have given documents. For a minute, my lords, for a minute. My lords will notice page 153 as annexure M, my lords. My lords, distance between my crushing unit and KR Sagar Dam, the whole plan, my lords. Kindly notice that, my lords, the latitude, longitudes are there, my lords. The
No,
length
we
is
don't
showed.
have, we have read the papers.
Yes,
Therefore,
but-
we do not permit many of the advocates to argue at all. On facts, we come with full preparation.
So it is 20.8, my lords. So we wrote to them, how do you make the measurement? From where do you do the measurement? My lords, department wrote to us, my lords, we make the measurement from the center of the dam the latitude and longitude were given to us. From the center of the dam, my lords, I am at a distance of 20.8, my lords. The quarry from where I'm getting my stone, my lords, is at 21 kilometers. Quarry is running. Crushing stone, which is at 20.8, they have prevented. This
All
is where I
these-
stand.
All these things, courts, we do not have that expertise. Therefore, there is a committee. Committee is a statutory committee comprising of the high authorities, experts. And Mr. Sondi has no interest in opposing you or supporting the state, etc. Amicus curiae.
Yes, ma'am.
We took his assistance in that matter. He suggests even these applications, let them be scanned by the committee. Then whatever happens will happen.
My lords, could I just add to that, my lords? This Dam Safety Act, my lords, which came about in 2021, my lords. That's the act which has come about. What the expert committee is now scrutinizing, my lords, on the basis of the order passed by this court. One is on the aspect of the impact of mining activities on the dam.
No, we will direct now that expert committee should assist us in deciding your petition. We want some inputs from the expert committee. Not that they have jurisdiction under the act. Court can ask any committee
My lords,
to assist us.
yes, my lords, I do understand. But in cases which is beyond 20 kilometers.
You have said that now. That is said now about 3-4 times. There is nothing big argument
Because
in that.
our unit is shut.
The
Though I'm
same,
beyond.
same argument was made by L.M. Chidanandaya.
My lord, they were inside.
fact,
My lords, I'm sorry, my lords, my understanding.
matters, yeah.
In other matters, their crushing unit was inside this 20 kilometers, but what they were pointing out, it is not part of the mining activities. Because mining involves, my lords, ultimately seismic activities. You are going to be digging, boring, that affects the dam. In mining, you're only putting the stones in, getting out M sand.
Things are not that simple. Things are not that simple. It is only tip of the things we will argue. It will not be that simple. Because we have accumulated expertise as to how the blast activities take place, how mining activity takes place, what all things will happen. We will not be, the state will not be in a position to monitor everything
Yes, ma'am,
24
I
hours.
understand.
And to use words of Byron, within an hour, folly of an hour of a folly, the kingdom may lapse. That may happen to the dam. Therefore, we made that order.
I agree, my lords. My whole endeavor is
have inputs.
I wouldn't come within the purview of my lord's order, my lords. My lords,
That committee give us the
Committee is not a part, is it?
no,
the statutory.
my lords, one aspect, my lords. My only endeavor, my lords, was to say I don't come within the purview.
Safety.
Dam safety committee.
My lords, we have two committees
State-
under that, my lords.
State
State
level
and-
Under the
Dam
dam,
safety
is under dam safety act.
Act itself.
State
New
level dam
legislation.
safety committee. Under section 12 of the act.
State
Level dam
State
safety
level
committee.
dam safety.
My lords, there are
committee,
two
because there
committees,
are two
national
committees,
level and
national
state
level
level,
and
if I'm
state.
right. Could I just pass that safety act itself? There are two committees, one is at the national level and one is at the state level, my lords. So I understand now what they're addressing is the state committee would meet to consider all the applications, my lords. All other applications are ones, my lords, which are within 20. I may be the only one who's outside 20, my lords.
We'll ask them.
Even that aspect perhaps. the
Can be
committee
looked
could-
into by the
Because in
committee.
fact, if my learned friend's client was clearly beyond 20, I would never have anything
I
to
am
say.
beyond 20.
But it seems that
My lords,
friend
my
is
memo
just-
which I've given, Right to Information Act, they have given me a reply, I'm beyond 20.
I'm not on facts at all. But all I'm saying is, my
On
friend
some
says
greater policy.
he's just past 20, whereas my learned friend's statement shows he's 19 point odd. Now, that is a disputed question of fact. Perhaps the committee could also ascertain
Even that.
that
also.
aspect. If it's beyond 20.
Not only that 20 kilometers which we fixed in the judgment,
Yes.
it is not the value which we derive as students of geometry.
Quite so.
Not that way. Even if it is more, the committee can say,
There is
still
still-
it will
there
be,
is still a
pose a
risk.
potential danger.
Quite so, quite so.
That way. Therefore, we want to have the
In fact, initially,
views
your,
of inputs of the
initially your lordships had said 25.
25,
But
30 I
noticing-
said, but somehow because of very vociferous arguments, the distance came to be reduced.
And there was a DC order, my lords, which said 20.
Said the
Therefore, your lordship-
Mandya
That's
DC
right, that's
order.
My lords, in fact, my lord's order ran on the footing of mining activities, my lords. Only when the direction was given, elite activities came, my lords. My lords, towards the end, in the direction added that. And my lords, elite activities, whether crushing units come, my lords, that my lords should also consider. But my lords, when I'm outside 20 kilometers, me subjected to being closed, my lords, probably is outside the order of this honorable court, my lords. My lords, so my lords,
Ordinance, Senior Advocate Mr. Sandesh Chowta, assisted by Learned Advocate Mr. So and so. For the petitioner, Learned and Learned Government Leader, Learned Advocate Mr. Mahendra, for the respondent state authorities. You are also, Madam. The court had also the benefit of assistance of Learned Advocate Mr. Senior Advocate Mr. Sondi, who acted as amicus curiae in the present petition also. Also, the petitioner paragraph, the partnership firm has sought to call in question notice dated 20th January 24, issued by Respondent 3 District Stone Crusher Licensing and Regulatory Authority. A further prayer is made to direct the respondents not to take coercive measures against the petitioner in relation to the operation of the stone crusher and M-dash sand unit of the petitioner. The challenge is advanced to the notice, raising various grounds. The ground, the notice requires the petitioner to temporarily stop the quarrying and other activities to crusher oblique quarrying within 20-kilometer radius of the Krishnaraj Sagar Dam, Andhya district. He stated the notice refers to order dated 8/1/24 passed by this High Court in writ petition number 1983/24. In the said order, the High Court is required to stop the quarrying and crusher quarrying concerned further activities within such radius of the dam. The directions in the said order, also quoted in the notice, are as under. So page 26, all mining, 1, 2, 3. Besides that, the notice to the petitioner to arrest the quarrying and other activities is based on the aforesaid order, Learned amicus curiae invited attention of the court to the aspect that a state level dam safety committee has already been constituted and is functional Full stop. It is a committee constituted under chapter 5, Roman capital. Under the Dam Safety Act 2021. The full stop section 11 deals with the constitution of the committee, 11 of the act, whereas section 12 provides for the functions of the state committee. Full stop. It was undisputedly stated before the court paragraph that the committee seized of the very subject matter and the related aspects. It was stated further that the committee has been addressing the issue as to whether, in addition to the mining and crushing activity, which activities could be said to be falling under the category of allied activities, which become potent to pose danger to the dam site and the safety of the dam. Full stop. The impugned notice and the grounds mentioned the notice as the centripetal issue, which the state level dam safety committee has been considering and applying its mind. Full stop. Learned government pleader would submit in support of the notice that all activities potent to pose danger would be classified as allied activities. However, it is for the committee to take a call on this score. Full stop. In light of all the above, this petition is not liable to be entertained. It is open to the petitioner to approach the committee by way of appropriate application to seek consideration of his case and the grievance in accordance with the law. Committee may go into the various aspects related to the grievance of the petitioner, in addition to the aspects it has been addressing, and may take appropriate decision in case of the petitioner also. To the authority. The committee, don't write. The committee shall take into consideration all the aspects, including the aspects which may be raised by the petitioner, to include the same in the report to be submitted to the state government. With the aforesaid observations, this petition is disposed of as not entertained.
My lords, could we make one request, my lords? A time limit for it to be considered. Why reason is this, my lords? My lords, could I just say the reason, my lords? I'm given to understand.
Committee is considering
Just what has happened there, my lords? They were doing experimental blasting, my lords, as part of the experiment, and they were prevented from doing it. 50 persons would come there, and even the experiment on seeing what would be the effect of this blasting has been stopped there. If we don't have a time limit, my lords, probably this exercise will not happen, and these units may not open.
It's a very high level committee. Kindly see who are the constituent members,
Yeah,
section 22.
My lords may kindly know what exactly has happened there. If the prevention is for having the
These are larger aspects which we cannot decide at the arguments.
some time frame, my lord, some time
It's a very
frame.
high level committee. It has got onerous responsibility. We cannot fix. Otherwise, the main activity itself may be, its exercise may be derailed. You can request the committee, whichever. We cannot, because it's a very high committee. High committees are generally respected and assumed that they will function according to law.
Obliged.
Thank you, Mr.
I'm obliged. It's an honor.
Yeah. 38 urgent, serial number 39, to Murthy DN.
Serial number 39. Respondent number 6 is the contesting respondent.
The council is not well today. Requested to take up this matter next week.
It will go after
Please.
vacation.
December 40. The Sachin BS.
Universities in appeal.
Any similar matters we treated in?
Yes.
Treated or pending?
My lords, all similar matters are before your lords.
All matters are
Yes.
before us.
Common order was passed, my lords. Appeal against the common order, my lords. All appeals are here.
Yes, my lords, universities in appeal. My lords, I draw my lord's attention to the page 78. There was an ordinance which was ordinance which was passed by the university in the year 2012, governing evaluation of the paper. That 2012 ordinance was replaced by another ordinance, that is 29/3/2019. Page 78 may be looked into. It's page 78. My lords, it is a comprehensive ordinance. Page 78, that is ordinance which has been issued by the university dated 29/3/2019. My lords, in that, my lords, last paragraph, applicability. This ordinance shall apply to all theory answer scripts of undergraduate courses in medical/dental/Ayush/physiotherapy/nursery, pharmacy, allied health science, yoga, naturopathy, and not applicable for bio-clinic practical examinations. Next, my lords, page 79. General valuation means two evaluations conducted by two independent evaluators for particular theory answer script. My lords, I want to draw my lords' attention of this ordinance. This is a comprehensive ordinance which covers different courses such as medical, dental, Ayush, etc. My lords, each course has its own parent act. For example, insofar as the medical is concerned, this medical MBBS course is governed by the parent act called Medical Council of India.
MCI.
Yes, MCI. And so far as the dental course is concerned, it is also governed by a different parent act, dental council.
Similarly,
So it has got its
homeopathy
own parent act. Now, medical students has approached this court challenging this ordinance 29/3/2019. My lords would find it at page number 81. Page number 81. The grievance raised by the medical students, kindly mark this, fellows, medical students, MBBS students, what they said is that as per Medical Council of India regulations, which speaks about the valuation by a 4 evaluator, but university ordinance speaks only about the 2 evaluator. So this, our ordinance,
Held that it is applicable, your case is, it is applicable only to the MBBS student.
that is my case.
Rest of the people are excluded. From this. For them, 2 evaluators will do it.
In toto, yes.
Rights are not available. That question is answered by the
Yes.
apex
My
court.
lords, I would put
Shirva,
it-
he quotes it.
That is exactly the severability doctrine.
Severability, if we can't say severability, in a way it is a severability. In severability, what happens is the gangrene part is amputated. It's a case of amputation of a legislative limb.
My lord, statute void was been declared as in part.
Yeah, it is wide,
Void
part
in-
of that only.
Yes.
That is not a case here. Kindly come to page 91.
Yes,
Read the rock bottom paragraph.
yes,
In the above circumstances,
Yes.
these writ petitions succeed.
succeed.
A writ of certiorari issues,
Yes.
quashing the impugned ordinance in its entirety.
Yes. Thereafter, my lords further.
Thereafter, what will happen is consequence. Because medical students, MBBS students were before me, I said that way. That's how it is structured. You should have said, you hold this ordinance not applicable to MBBS students. That was not your argument. Your argument was on the premise, the statute made by the ordinance made by the university is valid, which we did not agree. Court in so many words said, it is struck down. Once it is struck down, it is struck down. Your argument is case of applicability. That is not the case which you have structured in your defense, means in the defense of the university.
Lords, let me
My lords,
put it.
paragraph 4, my lords, of that order makes it clear, my lords. They were not only MBBS students, they were all students before your lordships.
Before that also?
Several questions were raised. Your lordships noted this, my lords, at paragraph number 4, ink page 88, I presume, my lords. In mine, it is 87.
No, even otherwise, court
There,
says it is struck
it's
down
struck
in
down
its
its entirety.
entirety. Otherwise, it would be case of selective application of the ordinance to the category of cases, namely the MBBS students. It's not that way. Therefore, learned single judge went by the terminology of this judgment.
My lords, I would like to impress upon this court in this view. My lords, all that the MBBS students has contended is contrary to the Parent Act.
No,
My
there were
lords
other
has
students
accepted
also,
it.
he's pointing out.
Yes, my lords has accepted it. And my lords, my submission before my lords is entirety in the sense that it is only applicable in so far the MBBS course is
Not applicability, widening of the legislation.
My lords, entire legislation will not become wide. Because for the reason that, my lords, because the ordinance speaks not only about the MBBS course, also it speaks about different courses, which is gone by a different Parent Act. And my lords, in so far, yes, I'm sorry.
No, you need not be sorry at all. It's a debate, it's a war of wits. What we are saying is, see the terminology of the operative portion of the order.
Yes.
The operative portion of the order in plain English says, it does not admit any interpretation because it is as simple as can be.
Yes.
These writ petitions succeed. Writ of certiorari issues quashing the impugned ordinance in its entirety.
My lords, further, mandamus issued, respondent issued, cause violation of all tier answer to all the petitions that are for evaluation.
That is a consequential order because of this. It's consequential order.
Yes, my lords.
Then what is the
My
difficulty? You
lords,
should have sought for, you should have said, don't quash the entire in its entirety, make its application selective. For non-MBBS students.
Yes.
That was not your stand.
My lords, valid could be separated from what is invalid.
But we do not know.
My lords,
So the
doctrine of
judgment,
severability.
it appears it went in appeal also. Did it go in appeal? No appeal. It did not go in appeal.
My lords, now what happens is that the reason is this. Now the BDS student has come before this court. Other course people had come before this
We
court
do
and
not.
said that the 2019
enact.
ordinance has no life.
You
Only
should have
2000
enacted. You should have enacted another ordinance after this saying, we are making this ordinance for people other than MBBS students. You have not enacted.
My
You
lords-
left the field as it
My
is.
lords, ordinance, whatever, if though enacted to be only a prospect, it cannot be a retrospective. The reason is this, my lords. My lords, now the BDS students, other course people had come before the court saying that 2019 had no ordinance is now no life. We are gone by 2012 ordinance. Therefore, my lords, we are before this court, my lords, insofar as I would like to impress upon the court, my lords, the learned single judge has relied upon the order passed in WP number 3582 of 2021.
That is Justice Veerappa's judgment.
No, Justice Devdas judgment.
Which
Yeah,
followed
my-
this judgment.
He has followed my lord's judgment, and that judgment also is a subject matter of an appeal, where then an interim order is granted.
Let's see, this judgment.
So what does this Dr. Menaka Mohan say?
Please, my lords.
Menaka Mohan's
With
judgment.
respect
Yes,
to my
ma'am.
lords, how
My
third
lords,
valuation has to be
that's
done.
what I'll just pass
A
on.
formula has been.
My lord's judgment was relied upon by another coordinate bench. And this court has held that since 2019 ordinance has been quashed in entirety. So the evaluation insofar as the BDS course is concerned has to be adopted based on 2012 ordinance. That is prior to the ordinance of 2019. That order also is called in question before this court, which is where there is an interim order, my lords, in the writ appeal number 352 of 2021.
No, what does this Dr. Menaka?
Page
Mohan
50
say?
minutes.
My lords,
Page 50 minutes
Dr.
is the-
Menaka Mohan's case, my lord.
Only with respect to how third valuation has to be done. That's all, my lords.
Nothing
So that has been interpreted in that judgment. It is no.
There were put 5 steps. If the
Difference of
revaluation.
Difference of marks between the valuations is 15%.
Revaluation. If the difference of marks exceeds 15%, then it should go to third evaluation. Question arose, 15% of what? Therefore, I consulted a mathematician. What is meant by this? He gave a particular formula. Do you have that formula?
My lords,
Which is that formula?
Yes, my lords has
50 minutes.
laid on the formula for which we have accepted. University has accepted it. My lords has interpreted the formula insofar as 2012 ordinance is concerned, for which
Correct.
we are happy and we
That's
have
what,
accepted
that's what
it.
I was saying.
Now the single judge coordinate bench of this court says that since 2019 ordinance has no
Gone.
life, go as per 2012 ordinance, as per Dr. Menaka Mohan's case. Since
One
the
more
2000, our grievance before this court is that 2012 ordinance is replaced by 2019 ordinance. And 2019 ordinance is quashed, not quashed in entirety. It is quashed in entirety insofar as medical course is concerned. Other courses, BDA courses concerned, they have been gone under 2019 ordinance is by respectful submission. And my lord, this court, my lords, has relied upon the decision, that is WP number, my lords, WP number 3582 of 2021. That is impugned order which is passed by the learned single judge. Where in WP number 35821 of 2021, where the coordinate bench of this court has relied upon my lord's decision and has said that 2019 ordinance has no life. Therefore, go as per 2012 ordinance.
Now we're asking one small
Great,
question.
great.
Suppose 2019 ordinance.
Yes.
Repealed 2012 ordinance.
Yes.
Factually.
Yes.
2019 ordinance is struck down.
Yes.
Does it result into revival of 2012 ordinance? The authors like Crawford, Sutherland, and Crace on statutes, they say it is not revived. For example, 2010 legislation is repealed by 2020 legislation. Subsequently, 2020 legislation is repealed once for all. Whether that repeal revives the repealed act or not is discussed by the juries.
My lords, then if that is the situation, my lords.
That may come to.
Yes, that is the reason why that there is another writ appeal number 352 of 2021.
By why legislation. Subsequently, why legislation or repeal? Question arose before the House of Lords whether the second repeal would result into revival of the cannot. They said no, cannot. That applies where constitutional court will strike down legislation considered.
It's in this case.
Any
Look,
judge.
in this case, your lordship's judgment prevails. My lords. In this case, my lords, your lordship's judgment prevails as to how 15% has to be calculated. It is not just the legislation. Your lordships have interpreted that and a direction is issued to the university as to how 15% has to be calculated. So the judgment holds the field. Learned single judge has said, follow the judgment.
My lords is right. My lords has interpreted the ordinance of 2012 and my lords has held that this is how the evaluation has been done, which has been accepted by the university. Now our contention is that 2012 ordinance is replaced by another ordinance 2019. My lords, just to cut short my argument, my lords, just pass on the judgments under which the single judge relied upon. My lords, just pass on it. My lords, I just to draw my lord's attention to page number 21. Page 21, my lords, where learned single judge relied upon the judgment of Nasura Anjam. Page number, my lords, page number 21 of my memo. Page number 26, my lords, the learned single judge holds that my lord's judgment, that is Nilesh Mehta, wherein the 2019 ordinance has been struck down in entirety. Therefore, 2012 ordinance has to be followed. Kindly see page 27, para number 27. I'm sorry, page 27, para number 6. This judgment is, I'm sorry, this judgment where under which Lalan Singh relied upon. Again, this judgment is subject matter writ appeal. My lords, have a look at the page number 5. I'm sorry, page number 5. In that, my lords, writ appeal, my lords, page number 8. In that writ appeal, my lords, the judgment passed in Nusura Anjam case has been stayed. Page 8. Page 8, my lords.
It of the now which you have given. Appellant's counsel submitted.
Yes.
that ordinance is still in existence.
That is my, one part of my argument. Second is that now BDS course students came before this court. BDA council, the parent act speaks that, does not speaks about 4 valuation. Now BDS student has came before this court, saying that our paper has to be valid by the 4 evaluators.
No, my lords, sir. No, that was not the prayer, my lords. Again, it was with respect to third evaluation based on 15% difference of marks itself. So nowhere have BDS or Ayurveda course or anybody
Or
asking,
etc.
not at all. my lords. They have not asked parity with MBBS students, not at all, my lords. Only for third evaluation where there's a difference of 15% marks.
Now, what would happen if the formula which the learned single judge?
Yes, yes.
as a
My lords,
single
there is a
judge-
slight difference.
I-
Yes, I just want to point out.
Huh.
2012 ordinance speaks about when there is a difference of 15% and more of between 2 evaluators. That is the word prescribed. 2019 ordinance speaks something different. When there is a difference of 15% or more of the maximum marks prescribed in the paper.
University
I
wanted to
just
supervise.
point out the difference. 2012 ordinance, my lords will find it at page number 48. My lords, have a look at the page number 48. Page number 49, I'm sorry, page number 49 under the heading procedure for multiple valuation. My lords, got it, my lords? In that, that is point number 1. All the answer scripts which are subjected for double evaluation where the difference in the award of marks between 2 evaluation is more than 15% shall be referred to third examiner appointed by the vice chancellor chosen from the from approved panel. All answer scripts which are subject to 4 evaluation where there is a difference in the so and so award of marks of valuation 15% shall be referred to the fixed appointed by vice chosen for the approved panel.
No, we are asking you now.
Yes.
X
sorry.
minus.
I'm sorry, revaluation means
anything for
valuation
that.
conduct 2 evaluate.
If this formula, which I
Yes,
have meant,
yes.
para 26 of page 71.
Yes, yes, yes.
The formula,
Yes.
which we have adopted is.
Yes, yes.
X minus Y.
Yes, yes. We have accepted
into 0.5 into X plus 5.
Yes.
Tends to or negative tends to 0.15.
I'm sorry, I'll come to that, madam.
Yes.
Before that, kindly see page 49. My lords has adopted that formula basing reliance on page 49. Page 41, revaluation column. My lords got it? Page 49, ordinance 2012.
Perhaps we are not on the same page even in arguments and page numbers. Your page number is plus or minus 1.
My lords, page 49, ordinance 15, I'm sorry, my writ appeal number 1061 of 2000.
That's what.
Yes.
1.
I think your lordships have 1018, my lords.
1018.
Yes, my lords. I think he's referring to a different writ appeal. 1018 is there.
1018.
There is a confusion. 1061 I am referring to.
1061.
One.
All right.
There is a reason why there is a difference as such. All are same, my lords. Page 49. Page 49, my lords. Yes. In that revaluation column, kindly make a note of it. I'm sorry, my lords. I'm sorry. I'm sorry. Revaluation column.
Revaluation column.
Yes.
That is notification.
Yes.
Dated 15/6/2012.
Yes.
Huh?
Yes.
Procedure for multiple valuation.
Yes.
Yes.
My lords, in that general valuation means 2 or so and so. UG course 2, 4 valuation conducted as ordinance governing valuation for PG course wherever applicable. Revaluation means valuation conducted by 3rd or 5th examiner UG and PG as case may be as per the ordinance where deviation between any 2 valuation general valuation
15%.
15%.
More or less than 50%.
Yes.
15.
Now kindly see the 2019 ordinance. My lords, have a look at the page number 78. Yes, my lords, have a look at page 70. In that, deviation valuation
means
yes,
conducted by the third evaluator. It's on case of
maximum
deviation-
marks prescribed for the paper. This is a difference.
Correct. That is the problem which arose. Question was that the differential of 15%, is it to be worked out? The valuations done by two evaluators inter se, or this is important. This 15% is qua the maximum marks prescribed for the paper. The second part was your argument. I did not agree because text language itself is much different. We say 15% of the difference between two evaluators. For that, formula is also given.
Yes, my lords is right. My lords has interpreted the judgment by that when the my lords has passed a judgment, 2019 ordinance was not there.
Correct.
My lords has, because there was a confusion in the valuations as per 2012 ordinance, my lords has laid on the formula. This is how it has to be done, for which we are accepted. After passing of my lord's judgment, that is, we have replaced the ordinance of 2012 and we have brought new ordinance.
2019
ordinance.
Which says 15% of the maximum marks prescribed for the paper. Correct.
Now the student says that since 2019 ordinance is struck down, go as per my lord's, you should adopt the evaluation as per my lord's judgment, for which my lord's judgment has relied upon 2012 ordinance.
So you want court to assume that what has been struck down in entirety is not struck down. Striking down is qua the MBBS student.
Yes.
For others, the ordinance would continue. But that runs, that
Because
is
what
difficult
happens
to
is, that's
agree
how-
with the
my lords,
terminology of the
though-
operative portion.
My lords, though it is an interim order by coordinate bench of this court, what exactly my lords has held, since ordinance 2019 is not applicable, therefore go as per 2000 ordinance is the judgment which I have placed on record as per the memo. That the judgment was called in question in a writ appeal. My lords, page number 88, my lords, there's exact at the time of granting interim order, which is pending consideration, because each course has going under different parent act. It speaks about different parent act.
The university will not want to do it. Again, they have to reenact, promulgate the ordinance and do it for the next academic. So but now he's concerned. Things are settled. He wants the court to hold that striking down of the ordinance of 2019 in entirety is not striking down at all. The striking down is only for MBBS students. For rest of the students, it continues. That was not their argument also.
My lords, I can impress upon this court again, my lords, as a repetition, I should not do it, but I want to impress upon the court saying that please apply the principles of doctrine of severability. Because a statute is void only in part.
How can it apply severability?
Because my lords, now my lords has declared the ordinance only as a part of the statute, a part of the ordinance.
What is meant by in entirety?
In entirety, what my lords, because my lords has passed in the judgment. Ultimately, it's the MBBS students has came before the court saying that it's a contempt.
No,
of the
others were
parent
also
act.
there.
No,
Others
my
were
lords, I'm
also
sorry, my lords. My lords has quoted the reasons straight away.
Assuming.
Yes.
In fact, why should not you go back to Shirwai? Shirwai answers this question in a little bit different way. Shirwai treats two judgments of the apex court on this very discussion. One, I think, Keshava Madhava Menon versus State of Bombay, one judgment, 1949, something like that, under the old Government of India Act 1935. The other 2-3 judgments he has referred to, where a legislation is struck down under 13(2), whether that would continue as against those to whom Part 3 rights are not available, is treated by Shirwai in 4th edition, in 3rd edition and 4th edition. In both the editions, kindly go through, I may be wrong also, but I remember having read that.
Yes.
He has treated it as a separate under the separate heading.
Lords, as a repetition, I'm sorry, I'm wasting my lord's precious time. I know that. My lords, now BDS course are BDS course students are before this court. They are being governed under the parent act called BDS Council of that is BDS Council of India. That is a separate parent act. Parent act does not speaks about anything valuation of valuator by the 4 papers. My lords, if my lords.
No. Therefore,
Simple, irrespective of the whether it is in entirety or not. Something is challenged.
It is
Instrument, notification, order, whatever. It covers 1, 2, 3, 4, 5 categories. And somebody challenges it. The court sets it aside or quashes it.
in its
Goes,
entirety.
everything goes.
And not only that, because
Unless
you no, they wanted to give it retrospective effect. You wanted to give it retrospective effect when the parent act did not delegate that power to you. One paragraph is dedicated for that ground. There is one such paragraph, I remember. I am the author of that judgment.
I am all, my lords is before this court. My lords has passed on a judgment. My lords is the best person to decide what is the judgment which has been passed. If my lord says that 2019 ordinance is stuck down in entirety, rest with me.
The terminology of the order runs that way.
you can dissect.
And the doctrine of severability is in a different way, where the core legislative policy can be saved after amputating the gangrene part of a legislation, because it offends part 3, because it offends some power, because it transcends the legislative competence. To that extent, courts have said, there is a lot of literature on that now. In fact, D.D. Basu's first PhD itself was on that. Therefore, that it's not a case of the severability, invocation of doctrine of severability. Nothing is severed and retained something. Whole thing, it's a case of it's a case of death of a legislation by the stroke of the judgment. It's a wholesale death.
That's all.
It is already in the.
My lords, I would only request, my lords, a direction to the university to comply with the judgment within a short period. My lords, it's already.
But the submission was really innovative.
Very good. Very innovative. Very innovative. Thank you for your innovative arguments.
41 agents, number 42. Mohammed Zulfikar Ahmad.
What is the issue to the other side, my lord?
Waiting for the respondent, we'll undertake wakalat. We'll undertake wakalat for the respondent. Please, my lord. As she is out of station.
The petitioner, my lord. He is out of station.
By next date, we'll file. By next date.
Short accommodation.
Please, ma'am.
Date me. 2 weeks. Much more. 43 disposed, number 44. Mr. Yeshubaba Mishra.
Lords, on the previous occasion, they had undertaken to pass orders as per the impugned order. No orders have been passed as on date.
My lord, yesterday only I got a translated copy. So kindly grant 1 week time.
Number 45. The Prakash image.
And for the complainant, Your Lordship, today, this morning I have paid with the process.
I've taken the steps, Your Lordship. Yeah, please, Your Lordship, this morning.
Process has to be.
Please, Your Lordship, I've got the acknowledgement.
Learned counsel says the process is already paid.
Pleasure.
Contempt petition after service.
Number 46.
Lordship, I appear for
Full up.
respondent. Lordship,
Files has been-
order has been complied, Your Lordship. The office objection raised is the MD has changed. The party whom they have made, that MD has changed now, Your Lordship. And the present MD has shown the affidavit. Lordship,
Have you complied with order?
Complied. Order has
complied.
been complied.
Right.
Yes.
Order is also complied.
Order has been complied with. There were two minutes issue checks to me. That has been done.
The order and the contempt are complied with. Therefore, present contempt has been done. This.
Number 47.
My lord, I'll take steps, my lord. I'll take steps.
Steps to be taken. What is steps they have to take? Service of notice.
Number 48. Kalyan R.
Appellant, notice issued to respondent number 2 to 4 is returned unclaimed. May I request lordship to grant weeks time to take fresh steps.
Unclaimed is treated as served. Hold it.
Please.
Not refused.
Not refused, unclaimed, unclaimed.
It is also a service.
It's also given. Service may be held sufficient. But for hearing date may kindly fix.
My lord, a short date may be fixed because he is a senior citizen, respondent 6. He's already undergoing some treatments.
2 weeks.
Any, please.
The
Any
endorsement
urgency
on
or
the
after
board
vacation,
shows
it will be.
that respondent to
After vacation.
My lord, this month, my lord, because he is senior citizen.
2 to 4. 2 to 4 are the notice to the number 2 to 4 are have remained unclaimed. In that view, it amounts to service. Service under the Karnataka High Court rules. Of which year?
My lord,
No, there are 2 judgments which hold that way.
It amounts to service.
Service.
Lord, interim order may kindly be.
Valid service.
Lords may
Lord,
post it
interim order
any day
may
of
kindly
this
be
month. my
extended.
lords.
Interim order is there.
Interim order shall continue to. When do you want?
My lord, any day of this month, my lord, he is a senior citizen. my lord. He is a
Let
senior.
it go to 12th of June.
Please, read.
Number 49. R. Kiran.
Appellant in this case, my lords. I pray for 2 weeks' time.
Granted 2 weeks. Time. 2 weeks time is granted to remove the.
Number 50.
Lordship, I am appearing online.
3.3. These matters pertain to the high security registration plates. Your lordship said indicated a date to hear the matters finally. I understand my lords are rising now, but please, my very earnest request is kindly
Fix a
give us
date.
the earliest date at 2:30 someday before the vacation, lords. Otherwise, our appeals will be infructuous. They are implementing this policy, my lords, at a very rapid pace.
Lordship, I am appearing for one of the petitioners online, and I would join my fellow colleague there before Lordships on the same request sometime on this side of the vacation.
Some date we can. 16th of April.
16th, my lords, at 2:30 PM. lords.
All of you may request on that day, will remember that we have
Very well, my lords. We'll make a mention that morning.
Lords, would it be convenient for the 17th, my lord, subject to your lordship's pleasure, my lord?
17th is a holiday.
It's a holiday, I think. 17th is a holiday, lordship, or Ram Navami.
Holiday.
Very well, very well. 16th.
16th is good, lordship. Deeply obliged, lordship.
15th. 15th.
15th, all right, Mr. Kamath.
Yes, my lord.
Mr. Kamath.
Yes, my lord. No, 16th, I think it's a little more convenient, my lord, subject to your lordship's pleasure.
Lordships may have it at 16.
Yes.
We'll make a mention that
lordship.
morning to your lordships.
But there
So,
are
so
certain-
grateful.
My lords, may I make a mention? In this matter, my lords, there are, my
16th,
implement
15th.
application is there. But now what is happening is the petitioner has moved an application for seeking stay, whereby making allegation against the, my client also. My lord, which since we are a necessary party, my lord, our application be allowed. That is IA number 3 of 2023 in writ appeal 1444, my lord.
Can we allow that application?
Lords, they are anyway parties.
But I'm a party, but they're not serving us any,
Lordships would
anything.
consider that along with the main matter.
But the problem is they're not serving us anything.
You
I'll
sent
give a
full-
copy. I'll
full
give a
two
copy
set
to-
of copies, give it.
That problem will be addressed straight away.
I'm so
Very
grateful.
good. Keep your light. Grateful.
It's number 51. Anil Kumar S.
Service is not done, provided. But I am producing acknowledgement for having served the provision. Postal acknowledgement might not have.
You posted after, be on vacation, everything not was there.
I'm fine.
All right. All right. We'll take
Number 50.
Date may be fixed. What matter pertains to recruitment, a date may be fixed.
This side not. This side is not.
And after vacation,
Any
if a
other
date
matters
is
we have
fixed,
posted already. Heavy matters are posted.
after vacation, if a date is fixed,
10th of June.
please, I'm.
Even next week.
Number 52.
I appear for the meeting. But the office has raised an objection. The mandamus was issued only to respondent 2 and 3. Government should not be included there. Contempt now. Of course, in all the matter, this court took the view. Government should be a party.
No, in contempt proceedings, the parties who have suffered the direction alone are necessary parties. Rest of the parties we cannot, barring in very few cases where criminal contempt, abatement, etc.
We'll delete it. We'll file a memo.
Notice.
But
has
you
to-
will- Yes.
We are filing. So notice to after. vacation.
10th of June.
I accept notice for R5.
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 You delete the government. To be deleted. And amend the cost rate.
Right now we'll do it.
Okay.
'58, '59 and.
Mr. Acharya, any matter of yours? That was argued. Yes, yes. really.
It is possible Monday or Tuesday.
It's a case where award will revive or not.
Tuesday?
Please.
Tuesday.
Serial number 58, 59 and 60, Mala, contempt matter in which we have filed compliance affidavit. And it has to be placed before the regularization committee, which is not formed. One of the matter your lordship has directed and draft the contempt. Similar matters.
But your friends are not there, no? Petitioner. No, committee is not working. Committee is yet to be formed. They say within time bound way, once the committee is formed, they will place it before the committee within, where there we have given 8 weeks, 6 weeks.
6 weeks.
6 weeks we have given. In terms of that, can we dispose of the contempt matters? Yes. Serial numbers?
58, 59 and 60.
Okay. In all these 3 matters, the grievance is as to non-consideration of non-compliance of the order made by the learned single judge of this court. First, after service of notice, the learned AG appearing for the respondent submits that the committee for regulation of unauthorized occupancy is yet to be formed, and that would be done before long. First, he further submits that within a period of 6 weeks, once the committee is formed, the matter would be placed before the committee for taking appropriate action, and committee would be requested to hear and dispose of the subject applications in expeditiously. First, with this proposal, learned counsel appearing for the complainant is also satisfied. First, in view of the above, this complaint of contempt is disposed of. Same order in all the.
My lord. Lordship, serial number.
Apologies, serial number 53, my lord. The order continues to be violated because of which we are unable to use the bank account of the firm, my lord. There is extreme urgency. Contempt proceeding itself.
You said which, Mahendra, which are the matters we disposed of now?
58, 59 and 60.
58, 59, 60.
53.
I'm 53, my lord. A date you can use it next week.
What is it? It is under office objection.
Yes, my lord.
Then remove the office objection.
Please, my lord. There are only 3 office objections stated. One is that accused number, the last 3 accused have been.
The learned advocate, Miss, what is your good name?
KNS, my lord. That's my initial.
States that the office of will be removed within 1 week.
My lord, I have one submission to make. One of the office objections says that the last 3 accused have been made party to the contestation, although they were not parties to the suit. They have aided in content being submitted by accused number 1. That's the reason they have.
There is nothing.
Aided is not that.
No, I have a judgment to that.
There is a judgment. We have.
I will explain, my lord. I'll explain.
This is a contempt arising out of the directions.
Directions, civil contempt.
You
there.
can't enlarge.
Civil contempt there, execution contempt.
Execution.
These are employees of the bank, my lord, who acted on behalf of the bank in violating.
You can't think, we're in criminal matters, we can understand. This only in the form of execution of orders. Civil contempt it is.
My lord. One submission. Next witness. My lord, one submissions. My lord, serial number 56.
56.
Maybe on Monday or Tuesday, my lord. Because the doctors which are like 1,500 doctors who are radiologists, by the virtue of an order passed by the state government in pursuant to this central legislation, has been literally not able to function.
My lords, I appeal for respondent number 1 in that matter, my lords.
Yes. Legislation,
My lord,
central legislation is challenged.
Yes, my lord.
My lords, an identical matter has already been dismissed and it's before the Honorable Supreme Court, my lords.
Identical matter. Very same matter.
Please, my
Challenge
lords,
is to the very
the
same act.
Same legislation.
Therefore, we expect lawyers to be personally present, at least local lawyers.
Please, my
Otherwise, in
lords,
this
it is also
incommunicado,
pending.
time will be lost.
My lords, I'm sorry, my lords, I wasn't sure it would be mentioned, my lords.
Yenante?
My lord, serial
My
number.
lord, if the
50
date can be fixed in that matter, my lord, my humble submissions.
In all matters which are meant for removal of office of vision, 2 to 3 weeks.
Distribution.
My lord, may I make a submission? Serial number 55, my lord. Officer has raised an objection. Are the original photographs produced by the officers?
Dispense. Original photograph dispense.
My lord.
Rest of the offices shall be removed within 2 weeks.
No, my lord, that's the only office objection. That is the copy served on me by the Land Council for the accused. I cannot produce because I.
Therefore, we have dispensed.
Oh, okay. Right.